Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, have a seat, please. All right, the first case we're going to hear this morning is Anderson versus Crouch, and Mr. David, we'll hear from you.
Good morning, Your Honors. May it please the Court. Neither federal statutes nor the Constitution compel states to fund sex reassignment surgeries. The district court erred when it found otherwise, and Skrmetti makes clear the district court's error. Classifications that hinge on medical use don't turn on sex, so those classifications only need to satisfy rational basis review. Skrmetti tells us that cost, efficacy, and safety concerns satisfy that rational basis. And because medical use classifications don't turn on sex, they also don't violate the Affordable Care Act's anti-discrimination provision. Skrmetti answers that question too. And finally, Skrmetti does speak to the Medicaid Act, even if indirectly. There's nothing in federal law that requires state Medicaid programs to cover gender-affirming surgeries. And the Medicaid Act just requires states to establish reasonable standards for determining the extent of medical assistance provided to beneficiaries. Skrmetti counsels deference to states when determining the best course of action on public health issues.
Are you maintaining that under the Medicaid Act, the standard we should be applying is a reasonableness standard, and then we can look at Skrmetti's to what's reasonable?
Yes, Your Honor, and so the Medicaid Act specifically requires states to have reasonable standards for the extent of the medical assistance that they are going to provide, and that those reasonable standards are tied to the objectives of the Act, and the objectives of the Act are to provide the greatest amount of benefits to the largest number of people. And so within the Medicaid Act, there's the availability requirement, there's the comparability requirement. The availability requirement requires the states to determine the reasonableness of what they're actually providing within the realm of what is practicable. And states have different levels of practicability because they have different levels of funding available to them. And also the objectives change per each state because states have different populations. They have different health needs within those populations. So what might be reasonable for one state may not be the best course of action or the most reasonable thing for another state. And so reasonableness and rational basis are used pretty interchangeably throughout this court's precedents, also through the Supreme Court's precedents. So yes, that is how we are saying that Skrmetti indirectly speaks to the Medicaid Act.
Can I ask a predicate question here?
Sure.
Why is there a private cause of action after Medina under the Medicaid Act?
Your Honor, I think that after Medina, there is a very good argument that we have not had a chance to take to the district court, but I think there is a very, very good argument after Medina that there is no private cause of action because this is spending clause legislation.
I mean, it's the same statute. It's not like a very good argument. It's the very same statute that's in Medina, right? It's the same Medicaid statute. It's the same spending clause. Like everything in Medina seems to apply here. Right, and I understand you haven't made the argument, but it's the predicate question, right? You're asking us to decide how to apply the Medicaid Act, but it sort of seems like an odd scenario for us to be interpreting the Medicaid Act in an instance where, like, after Medina, it seems plainly obvious that there's no private cause of action here.
I think that that's correct, Your Honor, and just respecting the procedural rules, we didn't go down that road because we had not briefed that at the district court and because this court had not asked us to apply that.
Well, you can always, pre-Medina, there was a cause of action because our court in the Planned Parenthood cases had said that there was.
Yes.
Right, but post-Medina, and so once the new Supreme Court decision came out, it didn't limit you from raising it. It certainly doesn't limit us from addressing it as a predicate legal question. The parties can't agree that a cause of action exists.
Correct.
And force us to answer how it applies, right? We have to construe the law first to determine what the analysis is here.
Correct, and we think that there, post-Medina, that there is no cause of action under the Medicaid Act. It's dealing with the exact same provisions, but even if there is one, we still don't think that there is a violation of the Medicaid Act or any of its accompanying regulations. And so to briefly address equal protection, because we believe that Scrimeti does directly answer this question, heightened scrutiny isn't triggered when a state regulates a medical procedure that only one sex can undergo. Rather, when a program doesn't exclude an individual from benefit eligibility because of the individual's sex, but only removes one condition from the list of covered services, that's not a violation of the Equal Protection Clause. And that's exactly what West Virginia's transsexual surgery exclusion does. That's how it operates. Sex doesn't come into the equation. Transgender status does not come into the equation. The state doesn't ask whether a beneficiary is transgender or not. Transsexual surgery isn't covered for any Medicaid beneficiary regardless of sex or transgender status. It only classifies on the basis of medical use. So the only relevant question when looking at whether something is covered in this instance is, what is the procedure's medical use? If it's for treatment of gender dysphoria, then it's not covered. If it's for something that is within the list of covered services, for instance, breast cancer, it is covered, regardless of the patient's sex or gender identity. And because it doesn't turn on sex, there's no risk from which men are protected and women are not, and there's no risk from which women are protected and men are not. And the record also lacks any evidence of invidious discrimination. Plaintiffs only point to an absence of a reason that the exclusion was initially adopted over 20 years ago. That's not evidence of animus, and plaintiffs haven't pointed to any evidence.
They make this argument, and I'm not sure that's totally true. That's not the only thing they point to. They also say, it seems like to me, in the supplemental briefing, that there's a disparate impact. And that anywhere that there's a disparate, I'm paraphrasing obviously, but anywhere that there's a disparate impact, we should assume intentional discrimination. Or that is evidence of pretext or intentional discrimination. What's wrong with that argument? What are they missing there?
They're missing what the Supreme Court held in Personnel Administrator versus Feeney, which is that discriminatory impact is not sufficient because the question is whether there's a discriminatory motive. And it's much like all of the other tests that we talk about in this, it's whether it's something that is done because of the effect that it will have on a class or in spite of whether it's going to have that effect. And so they have to actually show that there was an intent to cause an adverse effect on transgender people. And that's what the Supreme Court told us in Personnel Administrator versus Feeney and all of the cases that came after that. The district court had that same mistaken belief that just because you can point to the fact that there is potentially an adverse effect on a certain group of people, that means that there is an intent. But that's not the question. It's whether there was a discriminatory motive. They have no evidence of that. And to the contrary, there's evidence that suggests that West Virginia does not have a discriminatory animus. The first being that they cover all gender-confirming care up to but not including gender-affirming surgery. So that would be a really odd choice for them to say you can have counseling, psychotherapy, psychiatric visits, hormones, lab work, and we're providing all of that based on a discriminatory animus. It just simply doesn't make sense. And it also doesn't follow whenever there is a rational basis. So that's the other part of Personnel Administrator versus Feeney, and that's why this isn't like the tax on yarmulkes in Bray, is that there is a reason that you can look at, and it's the safety and efficacy concerns and the cost concerns that West Virginia has. And our record described deficits that West Virginia was facing budgetarily, but the record also shows that there is a dispute, not just in our record, but worldwide about the safety and efficacy of these treatments. Scrimeti talked about the growing number of European countries that have stepped back from providing this type of care because of safety and efficacy concerns. And plaintiffs point to the inter-qual guidelines that the state uses for determining medical necessity. But all of those guidelines are in the record. This is particularly from JA 970. For every single gender affirmation surgery that's in these guidelines, it states that although there are many publications on gender affirmation surgery, most articles are observational case studies, have less than 30 participants, do not have strong evidence, or are focused on surgical technique, there is a paucity of published evidence that is adequately powered or designed to allow definitive conclusions on safety and efficacy of the individual surgical procedures. Even those guidelines say that there isn't good evidence here, that there isn't enough evidence to show that these are efficacious procedures. So West Virginia makes a reasonable choice when it says we're not going to earmark hundreds of thousands of dollars per procedure.
Is there any line that you think should be drawn? I mean, obviously, in an instance, maybe, at least hypothetically here, where there's a uncertainty about the line of the efficacy of these types of procedures. But is there a line where the legislature could no longer make that choice? The mere existence of any dispute, would that warrant sort of deference to a legislative judgment? So imagine counterfactually that the overwhelming evidence actually supported the efficacy of a given type of treatment. You know, bone marrow transplants, right? And forget the cost aspect of this. I just mean on pure efficacy grounds. But there's, you know, one guy who has a paper that suggests that the bone marrow transplant is not an effective intervention. Could the legislature rely on that one person against the weight of the evidence and still get deference from us on this type of a question?
I think they could, and I think that the reason that they could is because it's not drawing any discriminatory lines. And that, of course, would allow for instance, if there is a group of people that feel that they are not getting the health care that they need because, for instance, the legislature is looking specifically at this one person that everyone's kind of cast aside, that's a question for the political process for those folks to replace the people that are making those decisions. But the decisions are still entitled to some deference from courts because they are the ones that are asked and tasked with exercising that discretion under the Medicaid Act, the Affordable Care Act, and also Equal Protection. They are the ones that are allowed to draw those lines and provide the rational basis. And I want to move to the Affordable Care Act, which incorporates Title IX's prohibition on sex discrimination. And Title IX, in turn, forbids discrimination on the basis of sex. And that language is important for two reasons. First, Skrmetti said that mere reference to sex doesn't create a sex-based classification, and that's especially true in the medical context because some medical procedures are bound up in sex. So courts are tasked with determining the function of the words or labels, not just noting whether policy refers to sex. And that's particularly important here because this exclusion, as I just discussed, operates based on medical use. That's the only question that's asked. That's the only operative question. What is the medical use of this procedure? If it's to treat gender dysphoria, it's not covered. If it's to treat something else that is within the list of covered services, then it is covered. The second reason that Title IX's language is important is because it refers to a biological binary. So the Supreme Court recently confirmed that meaning in Department of Education versus Louisiana, and also text and history confirm Title IX referring to sex is referring to a biological binary. The Supreme Court in Frontiero, a year after Title IX was passed, said that sex is an immutable characteristic determined at birth. And that is important because Title IX's definition of sex does not include gender identity. So we end up right back where we were with Skrmetti and with Godaldig. The exclusion doesn't turn on sex. There's no risk from which men are protected and women are not. There's no risk from which women are protected and men are not. And the exclusion does not treat one sex worse than the other or one better than the other. So it doesn't violate Section 1557.
Talk about how you think our precedent on these issues plays in.
Sure. So plaintiffs point to Grimm, and Grimm looks at Title IX through the lens of Title VII, and it applies Bostock. So Grimm looks at it in really two aspects. First, Title IX says you can't treat one sex worse than the other. And then it looks at Bostock and says that the Bostock analysis is what should apply here. And Skrmetti doesn't say whether Bostock can go beyond Title VII. It may question that, but it doesn't make the decision. But Skrmetti applied Bostock's analysis just the same. and said.
So, but just to make sure I'm understanding, you agree Grimm controls us on
Yes.
the question of what Title IX requires?
Yes.
That requires that we apply Bostock or Bostock, I have no idea which it is. And then your point is, at that point, we then look to Scrimeti, because Scrimeti sort of in the alternative explained how to apply Bostock in this context.
Specifically in the context of medical use, and that's what we have here. So that the Bostock test is a traditional but-for causation test. You change one thing at a time and see if the outcome changes, and if it does, then you found the but-for cause. And here, a hypothetical application of that reasoning to West Virginia's exclusion shows that, again, that it just doesn't turn on sex. So if a transgender man seeks a mastectomy to treat his gender dysphoria, the exclusion would prevent him from receiving coverage. But if you change his biological sex from male to female, the exclusion would still not permit him coverage because he doesn't have a qualifying diagnosis. But if he does have a qualifying diagnosis, he could obtain the mastectomy regardless of his sex or transgender status. So neither sex nor transgender status is the but-for cause of the inability to get that coverage. The only but-for cause is the medical use. And the en banc 11th Circuit reached the exact same conclusion in Lang versus Houston County. They looked at whether Title VII required an employer-provided health care plan to pay for, quote, male to female sex change surgery. And the answer was no, and the court applied Scrimeti's read of Bostock and found that there was no sex discrimination, despite the fact that male, female, and sex, all three of those words appear on the face of the policy. And the result should be the same here, because West Virginia's policy draws a line between certain treatments which it covers and other treatments which it doesn't, and neither the Affordable Care Act, Title IX, Title VII, or Bostock prohibit that line drawing. And we've talked a little bit about the availability requirement, so I want to talk quickly about the comparability requirement for the Medicaid Act. That doesn't come into play here at all. The comparability requirement doesn't require a program to provide a surgery that may kind of roughly look like another surgery. That's the plaintiff's argument here. But what it actually requires is that there's no discrimination within the group of categorically needy, within the group of medically needy, and you can't treat medically needy better than categorically needy. That doesn't come into play here at all. And I see that my time is up. Thank you.
Thank you, Mr. David. All right, Mr. Gonzalez, Pagan.
Good morning, Your Honors. May it please the Court. Omar Gonzalez-Pagan for the plaintiff and the class. Your Honors, this Court can affirm the District Court's judgment below solely on any one of the statutory claims. And Scrimeti actually does not impact any three of these claims. First, I would like to turn to Section 1557 of the Affordable Care Act. Your Honor, we would still argue that the classification here is facial. I understand, and this is probably the third time for some of Your Honors here in this case, there has been colloquy about whether transsexual is actually just an adjective describing the service as opposed to designating the people who are obtaining the service. Your Honor, we maintain that it is actually targeting the people who are obtaining the particular service at issue. If Your Honors look at JA 1152 to 1153, it lists all of the exclusions contained within this program plan. And of all of those exclusions, this exclusion stands out because it doesn't describe any particular service, but rather a broad category of services because of who attains it. It doesn't describe LASIK surgery or weight loss program or optometry services. It refers to the people who attain it. And the use of the language is very specific. It doesn't describe a diagnosis. It doesn't describe the description of a condition or what the service would be, but rather the who it would be. Even if the classification can be considered facially.
Well, what's the language it uses? It's transsexual surgery. Isn't that the language it's used?
Correct, Your Honor.
Yeah.
Transsexual surgery.
And
But that includes a
Hasn't
whole,
the Supreme Court disposed of that type of issue in the pregnancy case?
Geduldig?
Yeah. How do you handle that?
Well, Your Honor, we argue that Geduldig in here is distinguishable, one, because here it actually specifically mentions transgender people by referring to transsexual as opposed
It
to
doesn't say people, it talks about a surgery. It talks about a surgery in the context of other surgeries like sterilization and LASIK surgery, surgery for obesity. And in other words, it excludes a whole list of surgeries, but at the same time, it provides all other treatments for transgender persons. Right?
That's correct, Your Honor, but here, transsexual surgery is not a medical term. It doesn't refer to any specific service, right? What we're talking about, and the services at issue.
Well, what do you
Are
think?
hysterect-
How do you say it's not a medical term? Help me understand what, you think, like,
It's not a
I'm just not sure I understand that.
It's not a diagnostic or procedural procedure that is performed, right? What the exclusion
It says
actually is
surgery.
referring to.
It
Yes, sir.
says surgery, uses the word surgery.
Yes, but it is referring
that's
to a
it.
whole host of surgeries.
Pardon me?
It's referring to a whole host of surgeries. It is referring to breast surgery, mastectomy, hysterectomy, penectomy, vaginoplasty.
Is that maybe analogous to a policy that would not cover cosmetic surgery? That refers to a whole host of surgeries. It's not a specific diagnosis, but it's a category of surgeries that wouldn't be covered. Why should that factor into our analysis, that they refer to an entire category of surgeries?
It's correct, Your Honor, that cosmetic surgery may cover a whole host of procedures as well.
Well, it doesn't, so
But-
why shouldn't we read this the same way, that it's referring to all manner of surgeries that are, one might say, sex change surgeries, I think other policies say, or this one may even say that other places.
Yes, Your Honor. Here it says transsexual surgery or sex changery, parens, transsexual surgery. Your Honor, I think the use of the descriptor transsexual is indicative of the mindset that went into the drafting of the surgery.
What's your
of the
evidence
exclusion.
of that?
Context, Your Honor. And I think this is also why Geduldig is not instructive in response to Your Honor of how this case should be decided. Here, there's ample evidence of pretext. In order to determine whether there's purposeful invidious discrimination, one looks at the totality of the circumstances, at all of the evidence. Here we have the use of the term transsexual, which on its face targets a particular population. We also know,
Except just stay right there. They provide sexual confirming care of all other kinds that are for dysphoria that are now being used except for surgery. That's the only limitation. So it's hard to say that they're discriminating when they actually provide care for dysphoria. They just don't provide surgery. And they don't provide surgery for obesity, which obviously would reduce medical concerns. That's a difficult situation. Or sterilization, or LASIK surgery for the eyes. It seems to me cosmetic surgery, acupuncture. I mean, these are all on the list. It's a long list of surgeries that they have determined they can't afford if they're going to provide as much care to as many people as possible. And you agree, we have a reasonable standard here, don't we? Both under a Medicaid Act and under the Equal Protection Clause.
thank you, Your Honor. No, we wouldn't agree that it is a reasonable standard. So as I was, I think, starting to presage, it is a whole context of factors that goes into the determination of whether something is pretextual. And here, that is but one factor. If I may, I would like to elicit the other factors that, when taken as a whole, the totality of them demonstrates that this is purposeful invidious discrimination by proxy. One, there is a mention of the term transsexual. Two, the effect of the exclusion falls exclusively, unlike the other exclusions that Your Honor just listed, on one population. Exclusively, not overwhelmingly, but exclusively. That is an indication of pretext. And Your Honor, to respond to
Yeah,
your earlier
I'm
question,
getting ready to ask you. Tell me why Mr. David's confused.
well, I think, Your Honor, we're not arguing that disparate effect or impact is per se showing on its own necessarily a showing of pretext. But here, it is a factor to be taken into account. And I believe both Feeney and several other cases, including Washington v. Davis, make clear that when there is such an exclusive, not just overwhelming, but exclusive effect, that can be a factor to be considered to determine whether there is pretext. So here.
So can you just give me, just so I'm sure I understand what they are, what are the other factors that you think sort of add to disparate impact? I take you sort of acknowledge if all you had was disparate impact, that was the only issue, then you would agree with Mr. David, that doesn't establish pretext or intentional discrimination. But you think we can, do you agree with that?
I would say that given the exclusive effect, I would
So
disagree.
no, so you
But-
think
but that's-
it's let me at least
Yeah.
finish, right? So you do think that disparate impact alone is sufficient?
In certain
But-
circumstances.
But assume for a minute that the Supreme Court's told us that's wrong, just accept that as a hypothetical. What are the things that you think are in addition to, like, what would you say, we don't just have disparate impact, we've got A, B, and C. Don't explain them, just give me the list of what are the other things that you think add on to disparate impact?
Certainly, Your Honor. Again, the term, the effect, here, that the rationale.
Wait, the term,
The term transsexual, the
Okay.
effect of the exclusion.
is that different than the disparate impact?
Yes, Your Honor.
In what way?
I believe that the crafting, the drafting is the fact that it doesn't mention the services at issue, but rather it ties it to a particular population, I think is a separate factor. But if I may just
I'm sorry,
elucidate
wait, can you just help me I just don't, I'm literally just trying to understand the words. I'm really not trying to fight with you about it, but I don't even understand what those words mean. So like, how about say that for me one more time? That
Yes, Your Honor.
it doesn't identify procedures? I mean, it talks about surgery, right? The procedures that it's talking about is like a class of surgeries.
That's correct, Your Honor. But when you design something, it is an intentional use of the terms that are being used, right? Here, it didn't
What if they
describe
used
it based on.
sex change? What if they called it sex change surgery? Would that change your mind?
I think it would shift the balance of that factor, Your Honor. But here,
But wouldn't you understand transsexual surgery to be the same as sex change surgery?
we argue that that would be another proxy for transgender people.
Well, I'm not asking,
It would be a proxy
I'm
within
talking
a
about the
proxy.
definition of words now. It seems to me you're suggesting, West Virginia provides care for transgender people who are dysphoric, who have dysphoric conditions. And the only limitation, they say, in that category, they will not provide surgery, transsexual surgery, which I understand, I thought was pretty self-evident that it just means sex change surgery.
Thank you, Your Honor. That is correct, but I think the use of the terms itself is indicative of the mindset and pretext. And Your Honors, if I may, so we have the terminology, the effect, but I want to add a couple of other factors.
Can I
pertaining-
just to clarify, right, that's actually what it says, right? In one place, it's called transsexual surgery, and in another place, there's a bullet point where West Virginia is enumerating what's not covered, and it says sex change surgery, in parentheses, transsexual surgery.
That's correct.
Right, so that's like a defined term. So we don't have to argue about what does transsexual mean here. They've defined it for us, sex change surgery.
Yes. And Your Honor, if I may.
How does that factor into your first of, I'm not sure how many pretext factors you're trying to get to here, but the first one is that one.
We'd like to
and
get past the first and second.
We're
but-
stuck on that one. How does that factor in?
Your Honors, I think the choice of language matters. And this could have, for example, this could have been crafted in a way similar to, say, the statute in Scarametti, in which the word transgender is never even used in that
Okay, West
statute.
Virginia wants to exclude surgery where a person's coming in and seeks to change his body from one sex to another. How do you propose they describe that?
Your Honor, I would posit that the statute in Scrammetti would be an example of another way to describe it. That is a less direct reference, using less outmoded terminology.
Give me a term that you think is less discriminatory. You think transsexual is discriminatory. I'm suggesting transsexual means nothing more than sex change, and I think Judge Rushing has just pointed out that's exactly what West Virginia has described transsexual to mean.
Your Honor, the statute in
But I'd like
Scrammetti,
you to propose a term that you feel is not discriminatory.
thank you, Your Honor. So the statute in Scrammetti would be an example. There it described a surgery attained for the purpose of treating the distress associated with the misalignment between a person's gender identity and their body. That is a definition of gender dysphoria, but that's another way in which to use terminology today.
Is there evidence to suggest at the time this statute was passed, that transsexual was viewed in the way that you're suggesting? Right, because we don't look at the words that were used today, right? We've got to look at them at the time they were enacted, right, which is not today. Is there any reason to think that it had some, like, discriminatory content that's sort of distinct from sex change surgery?
I would argue that yes, but I don't believe that the record does provide for that inference, other than the cultural and societal underpinnings that
The record
existed
just
at the time
doesn't
of
tell
the
us one way or
Constitution.
the other, is
That's
what you're
correct,
saying.
Your Honor. But, Your Honor, if I may, just to go briefly, being mindful of time, of the other factors, I want to point to the other factors that show that there is pretext here. For example, counsel on the other side for the state argues that, well, this is about effectiveness or medical necessity, or even questions about whether this is experimental, as was the case in Scrammetti. But we know that it's not about experimental concerns or whether they're even cosmetic surgery concerns, because those exclusions already exist in that list, included at 1152 and 1153. So it wasn't that, and it wasn't cost either. We know that because there is ample and binding testimony from defendant's own 30B6 witness, showing that they never considered, never looked at whether the cost at issue here was actually a concern. Not only that, but we have unrebutted testimony that it is actually more cost-effective to provide the care than not, because it actually permits less utilization of other services that actually the state does cover, say, for example, mental health services. So those justifications just don't hold water, given how the list of the exclusions.
Well, what's your explanation if you say it saves money, why West Virginia does provide treatment for dysphoria of all kinds except for surgery?
Your Honor,
I mean, you say that's an irrational decision?
Your Honor, I argue that it is irrational, yes, because I believe it is not a cost-effective decision.
Well, they say it is. They argued it is. They say that that they have to make choices. They can't provide all medical care for all people. They don't have the money for that. And so they provide a long list, a very long list of types of surgeries that they're not going to include. And I mean, we're talking about sterilization. We're talking about surgery for obesity, which it seems to me is a surgery that if somebody can have his weight reduced, he reduces a lot of risks, medical risks. And you could make the same argument that it's cheaper to do the surgery than to treat all the conditions for somebody who's overweight. And yet these are decisions made by the state that are rationally made. You may not disagree with them. I mean, you may disagree with their choices, but they're not irrational, are they?
I believe that the decision with regards to this exclusion is indeed irrational, Your Honor. And
Did you argue below that this was adopted with discriminatory intent?
We did argue that there was, all of the factors that I have elucidated were factors that were actually briefed and argued below and before this court earlier.
Yeah, I know
they're
it came
indicative of
up.
pretext.
I know it came up earlier, but sometimes we talk about things that actually weren't covered below. The district court obviously only ruled on didn't rule on intent, and I don't recall seeing that you made an argument about discriminatory purpose.
But all of this was argued in battling the justifications, if you will, Your Honor, with regards to the equal protection analysis. Your Honor,
But do you agree with the question that you did not argue that this exclusion was enacted with discriminatory purpose below?
We did argue that in response to defendants' arguments with regards to the Goldig, that the Goldig wouldn't apply, but even if it did, there would be ample showing of pretext. Yes, we did argue that.
Can you turn and address why Medina doesn't resolve the Medicaid Act claim? We say all the time that you parties can't stipulate to the law. You can't stipulate that a cause of action exists. It's a necessary predicate question for us. And rather than weigh into the sort of complexities of the Medicaid Act, why doesn't Medina just like direct us, particularly at this preliminary injunction stage, to say, not that the district court was like a bad actor when it decided, but now that Medina's been resolved, granting a preliminary injunction based on a private cause of action under the Medicare Act is like a little bit crazy now, or Medicaid Act, I'm sorry.
I wouldn't call it necessarily crazy, and Your Honor, I would also argue that different subsections within 1396A of the Medicaid statute may be rights conferring, and some may not.
In what way? I mean, I understand that,
And-
like, you haven't briefed this, but like, if you look at 23 and you look at 10, they have the same directive, they're part of the same plan, their spending clause. Everything Medina says applies to 23, A23, the same way it does to A10. I mean, I don't, it's like almost hard for me to imagine what the plausible argument is, other than like, it's Tuesday instead of Thursday, that would distinguish this case from Medina.
I appreciate that, Your Honor, and I would love for the opportunity to actually brief Medina if the court is so inclined. But I would argue that argument has just simply been waived. And
You can't waive a legal predicate, right? That's just not a thing that you can do.
well, Your Honor, actually you can, and we pointed to a couple of whether there is a private right of action is not jurisdictional. We pointed to the Buono, for example, Your Honor, from the Second Circuit, as well as a case from the Eighth Circuit that argue that in the Medicaid context, that whether a claim is enforceable is not jurisdictional and can indeed be waived. Your Honor, I would further posit that Doe v. Kidd before this court, citing to Lurks from the Supreme Court, also was indicative and in that case reached the merits assuming that there was private right of action, and did that because, as the Supreme Court explained in Lurks, whether there's a private right of action is not a matter of jurisdiction.
No, they can forfeit. I'm not sure they can waive it, but they can forfeit it. But then it's just within our discretion as to whether we wish to address the predicate question or we want to weigh into the complex statutory interpretation that you're asking us to do.
And it is, Your Honor, I understand that it's a matter of the court's prudential decision-making, whether to address it or not. Certainly, we think that there are reasons why the waiver doctrine does exist, and at no point, even today, they have argued that they've made an argument that private right of action didn't exist. In fact, Your Honor asked that very question in March of 2023, and defendants is about it even then as well. So,
Well,
and I think
the
it would
reason
be a
was at
fundamental
that point,
fairness.
binding Fourth Circuit authority said that there was a cause of action, right? Like that's what Medina reversed, was a whole line of cases from this court that said this very statute has a cause of action, right? And so pre-Medina, like it's not really an argument to make in the Fourth Circuit. Maybe before the en banc, you could have tried to make it, but you certainly couldn't make it to a panel. But post-Medina, right? I mean, we're all here talking about Scrimeti, and everybody's arguments have changed a bit because we have new binding Supreme Court precedent. Well, so too is Medina.
That's correct, Your Honor. But at a minimum, we would ask for an opportunity to brief whether particular provisions at issue here are right conferring or not. We haven't had that opportunity. And in any event, we would argue that there's waiver and forfeiture. And I think, given the, and I understand that I'm over, so.
I'm sure, Judge Niemeyer, I'll let you answer my questions. Thank you.
But understanding the prudential underpinnings of why there's a waiver doctrine, it's because it is ultimately, this is a court of review, and ultimately it is the issues presented by the parties that dictate.
I'm not sure it's jurisdictional. I think a waiver and forfeiture are matters that can be reviewed anyway, but I'm not sure we can create causes of action or recognize causes of action that don't exist. That's another problem. But anyway, why don't we conclude and have Mr. David conclude?
Thank you, Your Honor. We rest on our briefs.
Yeah.
Thank you, Your Honor. I want to start at the language of the exclusion, and we recognize that the exclusion does use outmoded language, but that was the language that was used at the time.
What's the language that's not outmoded?
Gender affirmation surgery or gender confirming surgery. That gender affirmation surgery is the language that's used in the interqual guidelines.
So it seems to me that's more confusing to affirm a gender when you're trying to change the gender to conform to the identity that the person has assumed. A person feels uncomfortable in a male body or a female body and wants to change his body to conform to his mental identification. That sounds to me like change, but I'm not sure that the language used is unclear. Maybe today it's more desirable to call it gender confirming or sex confirming, but
Yes, Your Honor. And at the time in 2003, gender dysphoria wasn't even a DSM-5 diagnosis. That didn't exist until 2013. So this was the appropriate language at the time. Now it's more correct to say gender affirming surgery, but regardless, it still refers to the same constellation of procedures that are used to treat gender dysphoria. At that time, it was called gender identity disorder. And if we said gender affirming surgery, that wouldn't change it. If we said gender affirming surgery, including and listed every possible procedure, it wouldn't change it because the function of it is the exact same. And that's what Scrimetti tells us is important. I wanted to also address the argument that this falls exclusively on one population. That's exactly what Godaldig said wasn't enough. That obviously only women can become pregnant, but the fact that only women are affected by that exclusion did not mean that it was a sex-based discrimination or sex-based classification, because it affected women who are pregnant but did not affect women who are not pregnant. We have the same thing here because gender dysphoria and being transgender are separate concepts. Gender dysphoria is a DSM-5 diagnosis, being transgender is not, and this only affects people who are transgender, who have a diagnosis of gender dysphoria, and who have a treatment recommendation of gender affirming or transsexual surgery. And I also briefly wanted to mention that the reason from 20 plus years ago that this exclusion was adopted doesn't matter. The only question is whether it's reasonable to maintain it now, whether there's a rational basis to maintain it now, and Scrimetti tells us there is. For all of those reasons, we ask that the court reverse.
thank you.
Thank you.
Yeah, I want to thank both counsel for your very fine arguments. We'll come down and greet counsel and then proceed on to the next case. All right, the next case we're going to hear this morning is Wilkins versus Hedseth, and Mr. Hinchelwood, whenever you're ready, we'll hear from you.
Good morning, Your Honors. May it please the Court, Brett Henchwood for the government. Individuals seeking to join the military must generally be free of health conditions that may affect their service, including when or where they could be deployed in the event of war. The military has identified hundreds of different health conditions that make individuals ineligible to join the military. These conditions run the gamut from food allergies to prior heart surgery, from IBS to migraines, and from sleep apnea to autism. And the list includes many conditions that are chronic but manageable with regular medications, such as asthma, high blood pressure, and diabetes. HIV is just another of the pre-existing medical conditions that the military deems disqualifying for accession. The distinction the military draws between individuals with HIV and individuals with no pre-existing health conditions is plainly rational and serves important military ends. Individuals with HIV, even when well managed with regular medication, cannot be deployed in all settings, present some risks of transmission that cannot be completely eliminated, create additional financial costs, and raise foreign affairs concerns not presented by healthy individuals. The district court's judgment here rested on a failure to appreciate the fundamental distinction between accession policy and then the military's policies about retention and deployment for individuals who are already in the military. At the accession stage, the military can reasonably determine that it's not going to accept individuals who present known circumstances, known health risks, that are going to preclude their deployment in certain circumstances. They may be deployable in some circumstances, but not all. And that's a decision the military can make at the accession stage. That's different from the judgment that the military makes with respect to retention for individuals who develop conditions after they've joined the military and after the military has invested significant time in training those individuals, putting them into specialized roles in some instances, and providing those individuals with extensive resources, and the military is already, providing those individuals with medical care and has full visibility into their condition and ability to continue to serve. So that, fundamental distinction really goes to why the military here could determine, if you look at the declarations provided, for example, by Colonel Blaylock or by Dr. Seminara, that there are going to be inevitably some circumstances where individuals with HIV, just like individuals with high blood pressure or other conditions, are not going to be deployable. So if you have circumstances where someone is being deployed to a frontline position that's going to be difficult to resupply, that's going to be in a small unit potentially, where their inability to donate blood to other fellow soldiers will be important.
Just to sort of turn to maybe the elephant in the room, can you talk about our previous decision on deployment? We are obviously bound by that. Mm-hmm. And you continue to reference back that we're making decisions at entry that are based, at least in part, on deployment. And we have a case, obviously, addressing the ability of the Army to make decisions about who they deploy. And one argument, obviously, is that case was just wrong, but that's not an argument this panel can do anything about. So can you help us understand how to situate the arguments that you're making in light of that binding precedent?
Absolutely, Your Honor. And that's the next thing I wanted to turn to, which is, that distinction between accession and then retention is going to be, is critical to understand the difference between this case and Roe, which is the case you're referring to. So in Roe, you had individuals who contracted HIV after they joined the military. So they're already in the military. And at that point, the military had said, we're going to discharge these individuals because we think they couldn't deploy to the Central Command region of responsibility, and because we have a policy that people with HIV just can't go there full stop ever, regardless of the circumstances of the deployment, or at least that's how the district court understood that policy. And what this court held in Roe was, no, what you have to do is at least give individualized consideration to those individuals and say, okay, no, I'm going to consider the specific circumstances of the deployment and decide, because there probably are some deployments you could do, and it's not appropriate to discharge those people right now without giving them that kind of individualized consideration. So that's now what the military does with individuals in that position. It undertakes an individualized consideration that considers things like, as this court recognized in Roe, the availability of medical services and pharmacy supplies and other things of that nature that are all the considerations that I think everyone should recognize limit the ability of the military to deploy these individuals. Roe didn't say you have to deploy these people in all circumstances regardless. Roe just said you can't at the outset decide that they're never deployable in any circumstances and discharge them once they're already in, and you have yourself a process for individualized determinations. And that's not, and so that's the fundamental distinction between what's going on in Roe and what's going on here. I mean, Roe is really about
Right, but-
providing that individualized
But
determination.
why shouldn't we read Roe to say, well, at entry, you've got the same question, right? So, because the individualized determination on the back end, on deployment, could say, listen, it's perfectly acceptable if you're gonna, deploy to a, non-combat zone, role where you're an accountant, that's a perfectly acceptable deployment, while, perhaps, sort of forward combat zone positions are not acceptable. But why, given that back-end decision exists on deployment, I think the argument would be, you can't just rely on deployment at the entry stage.
Right.
Help me understand why I don't pull those apart, given that now you have this back-end consideration. And so you just would have to say, like, HIV folks, they need to be accountants. And, we can debate whether paper cuts are a sufficient problem that causes an issue or not, or, whether combat zone is a sufficient risk or not, but that you got to do that on the front end just like you do on the back end.
Right. So that's an argument that the military can't have any disqualifying medical conditions effectively at all. Because you could make the same argument about high blood pressure, about diabetes, about asthma, about ADHD, about literally every other condition.
I don't disagree that the logic goes there, but that doesn't mean that that's not what the logic is.
Well, I recognize.
I'm trying to take Roe, which is binding. I'm not necessarily saying that its logic is like,
Yeah,
is right. I'm just saying I got it.
I
Right?
don't.
And so now why, I understand you might say, okay, well, Roe only applies to HIV, and it wouldn't apply to high blood pressure. And so, but maybe we think the logic of Roe applies to high blood pressure just like it does HIV. And so why wouldn't that similarly demand at entry that the Army has to take everybody? The slippery slope is not always a fallacy, right?
Right.
Sometimes it's just like the effect of logic.
Well, Roe itself said it wasn't talking about, accession policies. It said it was focused on this question of what you do with folks who develop these conditions
Right,
after
but just
joining the
because you
military.
say you're not talking about something doesn't mean the logic of what you say doesn't apply beyond the very facts that you have.
Right. But so the fundamental distinction, which again, I actually don't take plaintiffs to dispute here, is that the military can make a judgment up front, ex ante, at the accession stage about what risks it wants to take on. And if somebody presents known risks that will limit their deployability of whatever particular type, whether that's medical or some other, the military can decide, okay, we're not going to take that risk. We are going to instead, pass on that person, and we'll take other people who don't present those known risks. And the idea that the military is forbidden from doing that as a constitutional matter or as a matter of just basic rationality review would be pretty astonishing. That's not at all what this court was saying in Roe. What the court was saying in Roe is that it was unfair when the military had policies that it was applying to other conditions.
Why, you haven't mentioned, and I'm wondering why, as these questions are being raised, is there a distinction between someone who is already in the military, to whom the military has accepted and now has responsibilities to take care of them, as opposed to who is going to be accepted in the military at the initial stage? It seems to me at the initial stage there are no obligations of the military to take somebody. But after accession, and once somebody's in the military, there may be obligations, if not probably legal, but also moral and military-wise, to take care of your soldiers who become susceptible to some kind of disease or medical condition, or even a wound in the course. It seems to me that that might provide a basis for distinguishing to some extent Roe and this circumstance.
Right. Well, certainly nobody has a right to join the military, and so I think you're right to draw that distinction. And I mentioned a few minutes ago the distinction.
I'm not sure I'm really asking this because this idea comes to mind, is that once somebody's in the military now has some obligations, and they, instead of throwing them out, they ought to take care of them. That's the idea.
Right.
Of Roe, whereas here the question is, can the military screen persons based on medical conditions before they take on individuals and then create that obligation.
Yeah, and I think part of a central part of the holding of Roe was it said, look, to the extent the military can provide this kind of individualized determination, and it's for individuals who are already in the military, rather than just discharging them with no individualized consideration, it should do that. Because yes, once there's that relationship, there may be obligations, legal or otherwise, that are formed, that the military has to abide by. And that was part of the crux of this court's holding in Roe, was that the military hadn't abided by the sort of regulations it had in place. And I also mentioned the fact that just as a practical matter, when individuals develop conditions after they join the military has already invested significant time and training in those individuals, and may have an interest in making a judgment about those people, that it wants to retain them despite their condition because of the valuable skills they developed or whatever other reasons the military may have. None of that exists at the accession stage. The accession stage, the military can absolutely make the judgment that it's going to avoid these known risks, it's not going to take on these known concerns, and then that's.
Where's the word accession come from? I found it to be strange.
I'm not sure exactly, Your Honor. I mean,
Is that a military term?
It is, and it refers to the just enlistment, induction, or appointment.
Yeah.
So becoming a member of the military, joining the military, is all that is. For the most part, there are some circumstances where folks already in the military, the accession standards apply to them. But by and large, we're talking about people joining the military from civilian life.
Can your case be made even without these medical rationales in attempting to distinguish Roe? What you were saying just now made me think of your cost argument. You have an argument about the cost the military is willing to take on that wasn't addressed in Roe, and then the sort of diplomacy rationale that it seemed the Roe court was saying we don't see the evidence in the record for that, but they didn't seem to rule out the possibility. And you're not talking about those today, which makes me think maybe they're not your best arguments, but I want to get your perspective on whether all of these are sort of independently sufficient or whether they work together, or how should I understand your arguments?
Yeah, so they certainly are independently sufficient. I believe I mentioned them at the end of my introduction. I'm certainly not running away from them.
Sure.
Absolutely, those are additional independent reasons that were not addressed in Roe that this court could could reverse on in this particular instance. So obviously the military does incur additional costs and can make that judgment up front that it doesn't want to take individuals on who are going to incur known costs, as opposed to individuals who may develop conditions later in their service. Obviously the military can't know that at the outset necessarily. And then the same thing to the extent that the particular condition precludes deployability to some places because of entry bans or other things that the military addresses, that obviously is an additional reason why their deployability is going to be limited. So, all of those are independent reasons, and those two were not addressed in Roe. I started with the sort of medical and logistical rationales, because I think even taking at face value all the sort of statements this court made in Roe about HIV and its treatment, the military still may rationally determine that it's not going to allow those individuals to access in the same way that it makes that determination for high blood pressure or any number of other conditions that might be manageable with medication that have literally no risk of transmission. In HIV, as this court pointed out in Roe, the risk of transmission may be very low for individuals whose HIV is well managed with antiretroviral medication, but it's not zero, and there are certainly circumstances. For example, the CDC guidance talks about occupational exposures in a medical care setting, that you cannot fully rule out the possibility of transmission, and so caregivers who are exposed to potential blood-to-blood transmission are supposed to receive treatment and testing for a period of time thereafter. And in the military context, that could mean taking soldiers off the front lines, taking military doctors out of hospitals or field care situations, preventing them from providing care to others in the meantime, potentially having to evacuate them out of a particular area. So it's just plain that there are going to be circumstances where those kinds of decisions are not things the military has to be put to, and it can make the judgment up front that it's not going to take those risks on at the outset. I'm certainly happy to answer any questions the court might have about this or the remedy or anything else. Otherwise, I'd reserve my time.
Thank you.
Thank you.
All right, Mr. Schotes.
Good morning, Your Honors, and may it please the Court. Scott Schottis on behalf of the plaintiff appellees. I'm going to address the merits of the case, and my colleague, Ms. Goberly, will address the relief. Misconceptions and irrational fear. They've surrounded HIV and the people living with it since the very beginning of the epidemic. Some concerns and even fears were justified, while others were not. They all were a little more understandable when AIDS was an invariably fatal infectious disease with an unidentified cause and no available treatment. But 44 years later, we have not only identified HIV as the cause, but documented precisely how the virus operates and how it is and is not transmitted. The first effective treatments became available nearly 30 years ago, and with adherence to those combination drug therapies came not only robust immune system and a return to health, to full health, but also the ancillary benefit of a greatly reduced or zeroed out risk of transmission through any type of contact. Today, a person living with HIV who regularly takes their one pill, once a day regimen, as do Isaiah Wilkins, the two pseudonymous plaintiffs, and 99.8% of service members living with HIV, is as capable and healthy as a person with a similar demographic profile and no chronic condition. So that begs the question, why is the military still acting like it's 1981? The answer?
Can you help me understand, I understand the jury argument, but can you help me understand why your argument is limited? Right, so you want to talk a lot about HIV, I understand, but I take your argument effectively to be that the military can't do any of these exclusions, high blood pressure, diabetes, hepatitis, right, like all of the limitations that the government has. I think the logic of your argument is that the government just can't do any of them. They're all irrational because all of them are things that can be managed with medication, at least maybe not literally all of them, but many of them, the ones I just listed, can be managed with appropriate medication. They present, in many cases, no risk of transmission, like blood pressure. In the hepatitis context, limited risk if properly treated. And so it seems like to me your attack here is actually not about HIV at all, but it's about the ability for the government to limit who gets into the military at all. Do you agree with that? And do you agree that the logic of your argument will exclude many of these things? Or do you think there's a distinction here that matters, that you can limit the logic of your argument? I understand you're only presenting one claim, and maybe your colleague wants to talk about remedy. Obviously, the remedy would apply to one claim. But the logic here seems to like tie the government's hand in a variety of ways for admission to the military.
So no, we do not agree that that is the argument we are making, and I want to make this very clear. Our case should not have the effect that you are describing on any other condition, because what we're actually arguing is that the military has a set of criteria that they apply to all conditions to decide whether or not, in this case, a person can join the military with a particular chronic condition. They're laid out right there, 4 very specific criteria. We're saying people living with HIV, if you act rationally, meet all of those criteria. So it's a very fact-bound determination that the court found in row 2, what we call row 2, which is the case that was before this court, as well as then in the district court on the further proceedings in that case, and then again in this case in Wilkins, that when you look at each of the justifications, they do not apply to people living with HIV. Those criteria that they
also don't apply. I mean, if you're right, if all of that's irrational, the logic of that would apply to lots of the other exclusions too, right? You don't get to just say, no, just give me my relief, even though the logic of my argument will apply to lots of these other. And maybe, I don't think that's the end of the world, right? Maybe it may be right that the Army doesn't get to pick who they admit, right? That it sort of like gets delegated to, a bunch of folks in black dresses. We get to decide who goes in the Army. I totally acknowledge that might be the right world to live in. But what I don't understand is this like effort to sort of pick out this one disease and suggest that it is somehow different than high blood pressure or, hepatitis or many other diseases that are well managed by the medical profession, and, don't present risk, at least insofar as a given individual is working as an accountant at some, rear facility in Stuttgart that's any different than being in Atlanta.
So we're not drawing that distinction either. We think that, we have established that a person living with HIV can deploy anywhere and in any position. That is really the crux of the holding. It's not about in a certain position within a deployment. But more importantly, we are not asking or not saying that the Army, that the military should not be able to apply its criteria. Those criteria are clear. They are in the statute. They're the reason, actually, that the Fourth Circuit said they have the ability, this court has the ability to assess whether or not the defendants are acting rationally in this circumstance, because there's a manageable list of criteria that you apply to each condition. So no, those criteria, when you look at what they say, free of contagious diseases that will affect the health of other members, able to deploy to any location, basically, without any effect or further effect on the treatment, able to perform their duties. So there could be, and the list of things.
Let me ask you, just to follow up on that. Why blood pressure? You can take a single pill and reduce blood pressure quite effectively. Why is that justified under the list in your judgment?
So I can give you my, sort of response to why I think.
Well, you're applying those criteria, and I want to understand. In other words, what I'm getting to is if you apply that criteria, and reject blood pressure, it seems to me you would have to, because HIV is an immune condition that is controllable with the taking of a pill a day, and as is blood pressure is controllable with taking a pill a day. And it seems to me there is a cost as well as some practicality at doing both in both cases. So tell me why you think blood pressure is justified.
So there are various reasons that we learned about during this litigation that the military uses or that places things on that list of disqualifying conditions. Some of them are things that directly affect immediately a person's ability to perform their job. If you were missing an arm, for instance, then you can't accede.
My hypothetical deals with high blood pressure.
So with respect to high blood pressure, I think it is their assessment of if they're taking someone who has high blood pressure now, what does that look like 5 years from now? What does that look like 10 years from now? What does that look like across the career of that person joining the military? This is my understanding. As opposed to HIV, like this person today is going to be, with respect to their HIV, the same that they are 5 years from now, the same that they are 10 years from now.
Isn't there evidence in the record that says that taking the pill may not change the fact that there are secondary conditions that can develop 5 years from now, 10 years from now? You're more susceptible to additional conditions. I mean, that's just the argument you made with high blood pressure. It seems like it would apply equally to HIV, and here we are, again, with 3 judges trying to figure out the difference.
Yeah, so with respect to those, what are claimed as comorbidities or secondary conditions to HIV, there's not a lot of evidence to support them. They were addressed by the court
There's
below.
not a lot of evidence either way, right?
With respect to?
Whether taking the pill daily will change your long-term susceptibility to these secondary conditions.
No, I think the question is whether having HIV, not taking the medication, but whether having HIV leads to having further susceptibilities to other things, but the science is not strong on that, and it has also been, over the past 40 years of the epidemic, we don't have a lot of evidence, right, about...
So that's how I draw the line. Like, how do I draw the line as a legal matter between, well, that science is not enough and that's legally forbidden and the military cannot exclude someone because of that, but high blood pressure is because, why? How, there's like more studies? What's the
Well,
argument?
Indeed, there has been, right, we've been studying high blood pressure for a long time, and we understand some of that stuff better than we do, say, HIV.
That might be a reason for them to be able to make the call if we understand it less.
I guess what I would say is that it is a speculative argument that, there's going to be some other things that are going to affect people living with HIV as they get older that do not, that do not affect the general population. It's very speculative. Whereas with respect to high blood pressure, it is known risks.
You were with us in the last argument, I assume, and one of the challenges that we have, right, is that the Supreme Court tells us over and over that which logic ought to be obvious, and that is where there's uncertainty, like the elected branches, not the judicial branch, gets to make those calls, right? Whether sex change surgeries are effective or not, the lack of information and the uncertainty, right, gives the elected branch the authority to decide what to cover or not cover. And why isn't the same point applicable here, right? The executive branch here has some uncertainty. As you say, we haven't been studying HIV, but 44 years, is that what you said? I don't remember exactly the number you said, but we've only been studying it for 44 years. We don't have perfect data with respect to comorbidity or the like. And so it seems like to me, the executive gets to make the judgment call given that uncertainty. Why isn't that like just like the same idea that we've just applied in Scrimeti?
So, one, I think, the uncertainty is about what happens to someone as they get to, 50 or 60 living with HIV. We know kind of like short-term effects, what kinds of things are happening and don't happen, and how healthy a person is in terms of once they're on these medications, they have returned, they've gotten rid of basically the problem, which was that their immune system wasn't operating, and they are returned to pretty much the same life expectancy.
Wait, but pretty much seems like a big word there, right? So like, this is the challenge here, like, pretty much is doing a lot of work in the sentence that you're giving us. And I don't know whether pretty much means like the same or pretty much means like not the same, right? I mean, that's a big difference. And you're asking me, who's not a doctor and does not do like public health work in any sense of the phrase, right, to tell the executive branch and all of their doctors and experts that like they can't possibly think that pretty much means something more than you want it to mean. I mean, like your own argument seems to make this point.
So I wanted to clarify, when I said pretty much, I was referring to life expectancy, which they haven't quite established is exactly the same. But everything else, there is just no difference in the capability. As a matter of fact, there is...
Well, sure. We can't take blood donations from a HIV person, can we? And soldiers often have to provide blood to each other, don't they?
That is correct. And on that front, the Roe Court, Roe 2, it said that was not a sufficient, that does not provide a rational basis for excluding service members from deployments.
Service members that are already members of the service, it seems to me the military has an underlying obligation to take care of its own. And that's played out in just tons of ways in the military. That's a part of the doctrine, to take care of our own. And when somebody contracts a disease while serving in the military, it seems to me Roe instructs that you have to take care of them unless there's some significant aspect. But here we're talking about the initial decision whether to engage somebody in the military. And it seems to me they could almost turn down anybody for no reason unless it's an unconstitutional classification, or race or whatever.
Well, and that is the point, Your Honor, is that they do have criteria that they use to determine. They don't just say, hey, we're going to exclude these people and not exclude these people. They have criteria by which they are determining this. And we have shown that the way they're applying those criteria to people living with HIV is irrational, arbitrary, and capricious. That is what, and I think this is really important.
Can I ask a question about
Yes.
Roe, because you keep coming back to it. Your colleague describes Roe as effectively a categorical ruling, right? That says the military can't categorically exclude existing HIV soldiers from deployment. Do you agree that that was what Roe did?
No, Your Honor.
I didn't think so. And so do you believe that Roe commands that the Army must send HIV positive soldiers to frontline military engagements?
I do not think that Roe commands that in particular, but on all of these issues, the Roe court was examining.
But tell me why that is. If it's not like a prohibition on the categorical decision, then I thought what you were going to say is no, they can't make this decision at all, right? So they must, if otherwise qualified, they must send a HIV ranger to the very front lines to engage with his comrades.
So I would definitely say that that is what the district court did in Harrison and did again here. As you know,
I'm not terribly interested about what the district court did, right? I'm sort of interested in what binds me, and that's Roe,
Right.
not the district court.
So what I think is binding from Roe is the specific determinations that they made about the various justifications being offered by the defendants as to why they wouldn't send this,
But the
how this person
justifications are
doesn't.
connected to the categorical rule, right? That like you cannot deploy, period. And so that this justification doesn't, or this reason doesn't justify a categorical rule. You can't disconnect the reason from the rule, right?
No, I do think that they have misinterpreted Roe. Roe talks about two scenarios. One, if there's a categorical bar, and then also if we're just talking about individual determinations. It examines both those criteria, and it says that these reasons that are being provided by the defendants are contrary to the science. I
The
think that is the
individual
key piece.
determinations part, so the court said, if the policy is to make individual determinations, the military didn't do that, right? So that itself is reason enough, the court said. And then they moved on to everything we've been talking about today from Roe, which is, or alternatively, if this is a categorical ban, here's why we think that's not acceptable, right? So, you're right that they raised the idea of case-by-case determinations, but that was separate from everything we're talking about today when it comes to what Roe thinks is medically provable.
So I think the holdings of the court in Roe are actually applicable either whether you're talking about a categorical determination or whether you're doing this on an individual basis, because they are about HIV and the effect of HIV on all of these questions. And the court said that basically the core of the justifications being provided by the military they contradict the science. They are incompatible with the science. So at their very core, these justifications, these reasons why they won't deploy these people, fail rational basis review.
Did the district court fail to consider the evidence that was in front of it in this case? The district court seemed to mostly be looking at Roe and the record that she had before her in those prior cases. But there's a different record here, which matters at least for arbitrary and capricious review. Obviously, the record does not restrain the government when it comes to equal protection.
So the district court was definitely looking at the evidence. You're right that I think the district court said that there was nothing presented that was new. So based on the fact that there was nothing of significance that was presented.
That's just wrong, right? I mean, there's the cost argument wasn't presented before.
I'm sorry.
Evidence about particular countries who have a diplomacy issue wasn't presented before. So what's your response to those arguments?
So let me clarify. The court actually at that time was talking about the medical justifications, that there was nothing new on the medical justifications. Obviously, yes, the cost of care and the so-called diplomatic deference to these discriminatory host nation laws were two separate issues. The latter had actually been addressed previously in the Roe case, and in the Harrison case, it hadn't been resolved. It had been left open. The court basically said, okay, I don't know if there's really these restrictions, but I'm going to, I can provide relief here without addressing whether or not people living with HIV can go to these particular few countries. The court left it open there. In this case, I think the court closed that loophole and said, no, now I've looked at it. This case has made this a ripe issue. I've looked at it and I've decided that indeed it cannot, the military can no longer say, you can't go to this country or you can't go to that country, because the diplomatic deference policy was irrational, because they didn't apply it to anybody except people living with HIV. With respect to cost,
Go ahead, you got 30 seconds for
okay.
cost.
With respect to costs, there are several reasons why. Obviously, you know, just saying that they're reducing costs does not automatically provide a rational basis. The district court appropriately excluded an unqualified witness offered to present untrustworthy evidence of cost, and the cost savings is arbitrarily and capriciously applied only to people living with HIV. It's the only condition. And finally, they accept and pay for dependents who need HIV-related care of service members. They let those people come into the military, pay for their care with respect to HIV, and
All right.
finally, they accept smokers, even though that is a much more expensive condition to treat over time.
All right, thank you, Mr.
Thank you, Your Honor.
All right, we'll hear from Mrs. Coberly.
Good morning, and may it please the court, I'm Linda Coberly, also for plaintiffs, and I'd like to spend just a moment on the remedy issue. Judge Brinkema entered her injunction in reliance on Fourth Circuit case law that is no longer good law in light of Trump versus CASA. And we've argued that the court could affirm on alternative grounds that CASA left open, including the APA 7062. But it would make just as much sense to address the remedy through a remand. Every case I'm aware of
Can
in
you
the
tell me
court-
today what the, like, state of the world is? Is the Army required under this injunction to be allowing HIV-positive individuals to join the Army? Like today? So
Yes.
if Bob shows up at the recruiting center and says, I'm HIV positive, but I promise you I'm doing everything I'm supposed to do and I'm clean, that the Army today is required in Kansas and Alaska and South Carolina to admit that person.
Yes, because
And you agree that that is like wildly overbroad in light of CASA?
I don't agree that it's overbroad if you understand the relief through the lens of the APA. So I do agree.
Which is not what the court did, right?
I agree with that.
Okay.
So that's why
So do you agree, at least as it currently stands,
Yes.
it's wrong? Either we got to provide another foundation for it that was not addressed by anybody, or we've got to vacate it and send it back.
I agree, and I think the simplest thing for the court to do would be to vacate it except for the part that applies to the three individual named plaintiffs and send it back for further consideration. We're fine with that. And in fact, I think a remand makes a particularly
And so we should probably, regardless of what we're going to do, if we were going to do that, we should issue a stay today to eliminate the illegal order on the Army with respect to at least everybody except for the three named plaintiffs.
I can't argue against that, Your Honor.
Okay.
I think.
Yeah, I appreciate it. I'm just trying to understand it. I'm not
Yes.
trying to push it. I appreciate you being straightforward with the court.
And I think one of the reasons I'm suggesting a remand, I'm going to suggest it for a couple of reasons. First of all, every case I'm aware of has held that it's the district court in the first instance that should assess the implications of CASA for the remedy, which is something that falls within the discretion of the district court. Secondly, it may make sense to remand here when there may be other grounds for remand as well, including for factual findings on a number of the topics that were discussed this morning with my colleague, for which there is currently no factual finding in the government's favor by the district court, and including that there was an expert who was excluded, and presumably if the expert were allowed to testify, there would be some additional fact-finding required, so a remand may be appropriate.
But that
on
doesn't make
basis.
sense if this injunction, it's an interlocutory appeal.
It's not, Your Honor, it's a
This is a final
judgment.
injunction, it's final injunction, and the scope of the injunction is too broad. Your argument is it'd have to be vacate that and give the court the opportunity to fashion the relief that is appropriate. But you also think the court should be given the opportunity to make other findings?
I think based on the argument that was made below, there is a basis for that relief as well, a remand for additional findings on the merits as well. And it would make a lot of sense to send the whole thing back for that reason. But I want to.
I mean, if the other things weren't addressed, it's like saying, you try a case and you try A and B, but you don't try C, D, and E, and then the appellate court says the relief is wrong, but we'll let you do C, D, and E also. I mean,
Well,
it's a little.
This appeal came to this court with cross motions for summary judgment.
Yeah.
Right? And the court could affirm, the court could, on the merits, the court could reverse on the merits. The court could also vacate and send the case back for additional fact-finding on the merits, and that's something we think the court should consider. When it comes to the remedy, if the court were to find either that there was a basis for a remand on the merits or that it was going to affirm on the merits, it should still vacate and remand, at least not vacate as to the rest of the relief, not to the three individuals, and send it back for findings and proceedings in the first instance before the district court. The government argues that vacatur was not at issue in this case, and that's just not true. Our complaint from the very first day sought a declaration that the regulations are unconstitutional in their face and a violation of the APA on their face, and to bar their enforcement, and that includes DOD 648501, which provides that HIV is a per se disqualifying condition, unlike things like high blood pressure, which can be waived by the military if the military concludes that the condition is not a barrier to service. HIV is different. That's why we filed this lawsuit. That's why we we filed it in the jurisdiction where the defendants live, not in any old jurisdiction like in many of these other cases. We filed it in the district where the defendants promulgated the regulations, where they make their enforcement decisions, and we asked for those regulations to be declared invalid. That is relief that can be justified under the APA, and the district court should have the opportunity to reach that issue in the first instance. Thank you very much.
All right. I guess, Mr. Hinshelwood, you have some response?
Mr. Honors, thank you. Just a few quick points. I mean, I appreciated my colleagues, their presentation. My friend on the other side said that they believe they have shown that the record demonstrates that individuals, and that the district court held, this court should hold, that individuals with HIV can deploy, quote, anywhere and in any position. In other words, regardless of all the considerations the military has identified about pharmacy supply, about the ability to provide treatment, about the ability of those individuals to donate blood, all the things that everyone agrees that were recognized in Roe itself as differences between individuals with well-managed HIV and healthy individuals, that this court should disregard all of those considerations, even though, again, they weren't directly considered in Roe, because Roe, as we've discussed, addressed a categorical ban on all deployments. The court's critical language on page 228 of that opinion emphasizes that the government had failed to explain a categorical ban on deploying HIV-positive service members. That is the crux of what the court was focused on. So, of course, the rationales discussed in that case were different and were focused on that question, not on the question of whether there are particular circumstances in which individuals cannot be deployed. And the military has demonstrated that's plainly true here, even accepting all the things the court said in Roe about the once daily pill, the fact that it's not, that it's resistant to or comfortable in extreme conditions, that there might be ways to mitigate the facts that individuals can't donate blood. Even accepting that all of that is true, there will still be circumstances where deployment is not appropriate, and that's clear, just as clear after Roe as it was before Roe. And it would be pretty extraordinary for the federal courts to be tasked.
So your colleague says that the district courts after Roe have said that you must send HIV soldiers to every possible deployment. Is the Army currently under an injunction that requires you to send them to whatever war zone you happen to be involved with at the time?
No, the injunctions that followed from Harrison and Roe at final judgment, after the preliminary injunction appeal this court decided in Roe, addressed this categorical deployment policy that was at issue in the first Roe opinion, and also address a separate question about moving from being an enlisted soldier to being an officer. That was the Harrison case. So, but those, neither of those injunctions requires the military to deploy them everywhere. And in fact, as we point out in a footnote in our reply brief, at one point the plaintiffs in that case filed a motion to enforce the injunction on the ground that they thought their deployments were being denied or somehow altered by the fact that they, had HIV even well managed. And the district court said, look, that's not this injunction. Maybe that's a different lawsuit, but that's not enforcing this injunction. That's something else. So there is no injunction right now that requires the military to deploy those individuals to all circumstances. And in fact, as we've explained in the brief, what the military does is it gives individualized consideration to whether a particular deployment is appropriate. But there would be no need for that type of individualized consideration, and there would have been no need for this court to talk about that in Roe if it was in fact true, as my colleague suggests, that you just have to deploy them everywhere all the time, regardless of any of the military's reasons for not wanting to do that. And again, many of those reasons would apply to numerous other conditions, not just HIV, to high blood pressure or any number of other things that are managed by medication. The military's ability to supply that medication to frontline positions, the military's ability to
Can you
provide
address briefly the injunction point? Do you agree that currently, Army recruiting stations all over the country are required by this injunction to accept HIV positive individuals?
Yes, that is currently the rule.
And that's based on the injunction in this case?
Yes.
And you agree that even if we were to believe that the merits were correct here, that injunction has to go?
Correct, yes, absolutely. Even if you affirm on the merits, you would have to narrow the injunction to apply only to the 3 individual plaintiffs here regardless, and we don't think plaintiffs now get to go back and try again for a vacatur. They never mentioned it before. It's not something, they could have requested it in the alternative. They never did.
What's your response to sending it back to have it be considered under the APA?
Yeah, I mean, for exactly what I was just saying, plaintiffs could have requested both remedies, an injunction and a vacatur. They could have requested those remedies in the alternative, but they didn't.
Her response is, we sought a declaratory judgment, and that the Declaratory Judgment Act, I take her argument to be that the Declaratory Judgment Act has a similar basis, and so maybe it's the same thing as 706? I'm not sure, maybe that's...
I don't take that to be the argument. I mean, I don't think that would be correct, but I don't take that to be the argument. I take the point to be, well, we mentioned the APA, and therefore, by mentioning the APA, that encompassed a request for vacatur, even though we never requested it. They didn't even say set aside. I mean, the language she quoted for you doesn't even include the relevant language from 706-2 that people rely on as the source for vacatur. And, obviously, this court shouldn't reach it for the first time here, and we don't think that they get now to go back and try again just because they're not happy with the way the law developed in the meantime. So I would just close by emphasizing that at the end of the day, it's the military's judgment, and the Supreme Court has emphasized repeatedly that decisions about the composition of a military force are entrusted to the military's judgment, and those principles of respect for the military's decisions about how to
Let me ask you a
address these
question on that. I
considerations.
know we're over time, but I'm interested in this standard of review. Both the Supreme Court and our court has recognized that we should defer to military judgments. What does that do to our standard for review, and what is our standard for review?
Right, so I mean, the district court addressed this as a rational basis case, and certainly the question here is just whether the military's decision is rational. I think
And
the same
does the
basic,
military deferment add any other layer on that?
certainly what this court should do should hesitate before second guessing the military's judgments about the composition of a military force. I think that's the force of the Supreme Court's cases on military deference, is to say, look, we have our standards review, but when you're talking about core military decisions, like who can be deployed, where can they be deployed, what individuals should make up a fighting force, those are core military decisions for which the military is uniquely competent and the judiciary is relatively less equipped to make. And so those particular decisions, we think absolutely it should influence the way the court thinks about it. I mean, I think under any standard of rationality, rational basis review, arbitrary and capricious review, whatever, what the military has said here is perfectly sensible, but certainly where this arises in a military context and we're talking about those core decisions the military has specifically singled out as entrusted to military judgment, it seems extra plain that the district court erred here.
All right, thank you.
Thank you, members.
We'll come down and greet counsel and take a short recess.
This honorable court will take a brief recess.
All right, be seated, please. All right, the next case we'll hear is Spencer versus Glazer, and Mr. Daniels, we'll hear from you.
Good morning, Your Honors. May it please the court. We appealed the district court here because the district court did exactly what this court warned district courts not to do. And in fact, a short circuit, the plaintiff's case at a motion to dismiss stage, were the plausible claims in that case, claims that were not blatantly contradicted by video evidence and the video and body camera footage of the officers involved.
Well, let me ask you this, just to step back on that proposition. Do you agree that it was appropriate to consult the video?
Yes, the video intertwined.
And your argument is basically the video doesn't contradict, so that based on that, on the Dorietti case, it has to contradict at its core the allegations of the complaint.
Yes, Your Honor, we have no issue with the video being considered. It's just how the video was considered. The video was intertwined with the complaint. There was no authenticity issues with the video. The issue how the court should utilize the video to come to the conclusion that the district court came to. And in fact, in the Doherty case, and I argued the Doherty case, Your Honors, in the Doherty case, the court said it has to blatantly contradict, and it gives some direction what blatantly contradict mean. I mean, it's utterly discredit the allegations within the complaint.
And you think that the complaint here and the video are harmonious?
I believe it runs just like a movie strip from the complaint to the actual body camera. In fact, we went to the SBI to look at the video, and the video was eventually provided by appellees in the motion to dismiss stage, and the complaint was written based on the video. In fact, it's not a...
What about gap filling? So I understand your point is that, you know, it has to blatantly contradict in order to do away with an allegation in the complaint. I totally get that, and, you know, it seems totally reasonable. What about gap filling? So what about places where the complaint simply says nothing? This is not a critique, right? You cannot include literally everything that happens, right? But if I was deciding, and I'm not sure it matters in this case, I'm just trying to understand conceptually, what do we do about gaps?
Well,
like, you know, maybe, you know, I don't know what gaps would really fill here, but just conceptually, what do we do with gaps? Once we're looking at the video, to the extent, you know, we've got allegations, we'll follow those unless they're blatantly contradicted. But where there's a gap in the complaint, do we fill that gap with what's in the, you know, authenticated video?
No, Your Honor, at the motion is dismissed stage, all reasonable interests will be drawn in favor of the non-moving party. In our position in this video, and I know Your Honor's answer hypothetical by gaps, not necessarily this issue, but when you look at the video, particularly in this case, we're talking about how this video runs directly with what happened. To the extent there's gaps, and our contention there's not any gaps there, I think we're crossing over more so of a Rule 56 stage instead of a motion to dismiss stage.
Can I give you an example just to help? Because I'm curious about this too, whether, you know, our court has said it has to present a set of facts that's contrary to what's alleged or blatantly contradict. But, you know, what if, and this, I'm just hypothetical, what if the complaint says nothing about what the officers said, right? There's nothing in the complaint about whether the suspect is disobeying the officers, right? But say the parties agree we can look at the video, and in the video, you can hear the officers saying, you know, get down, get down, get down, get down, and you can see the person not getting down, right? Or something like that. Put your arms up, and you see them not putting their arms up. Can we consider that?
I think at the motion to dismiss stage, the answer is no, because that person could be deaf and could not hear the officer. So it's issues that you have to go through discovery. It may figure out why do you
No, but
not.
that's not right, because we take it from the perception of the officer, right? So like, if it turns out the individual's deaf, that doesn't change the officer's perception.
I think you take the perception of the officers if you're talking about the issue of facts. You're dealing with facts. Here we're talking about plausibility and claims, whether relief where the claim state of relief can be granted, and you're looking at the complaint as to whether the complaint states that claim under Iqbal Twombly 2.
I'm still, I'm at a loss on your position here. I asked you a question whether we could consider looking at the video because the amended complaint was alleged to be, the reason for the amended complaint was to bring it in line with the video. Now, if the video were attached to the complaint as Exhibit A, we could look at the video, right?
You can look at the video.
Yeah. Now, in this case, it wasn't attached as an exhibit, but it was filed in response in order to bring it in line. So my question is, can we look at the video and take the video as part of the allegations of the complaint?
You can look at the video as to whether the video blatantly contradicts the allegation.
That's whether we can consider it at all. Doriotti basically said you can consider a video if the core complaint depends on the video and it blatantly contradicts. My question, and in that circumstance, if it doesn't fulfill those criteria, you can't consider the video, right?
That's correct.
All right. I'm suggesting that in this circumstance, why can't we consider the video regardless? Because the video is, in essence, incorporated in your second amended complaint.
Well, the video is not incorporated in our second amended complaint. It intertwines, and the complaint doesn't make reference necessarily to the video.
I know, but you asked to file, and the court granted, to file a second amended complaint to bring it in line with the video. That's what you said in your motion.
That's correct.
And the court granted that. Then the court looked at the video. So I'm wondering whether Dorietti even applies. In other words, why isn't this basically brought into the complaint through that process?
You know, the defendants, athletes, filed a motion to dismiss and added the video. We, in fact, amended our complaint in line with the video.
The second amended complaint is the operative complaint.
That's correct.
All right. And so the question is, you asked to file the second amended complaint to address the video.
Oh, I filed a second amended complaint after we looked at the video.
And you gave the court the reason you wanted to file it is to bring it in line with the video, right?
In line with the facts of what happened on the day of the incident.
And the court grants that. So now why isn't the court now entitled to look at the video, which basically you're saying was filed in order to be in compliance with the video?
Well, because the video was not filed with the second amended complaint as an exhibit attached.
I understand that.
The video was filed by the defendants in opposition to...
It doesn't matter who filed it. It's before the court, but can't be considered unless we have some kind of doctrine saying that's part of the complaint. Because the 12b-6 challenges the sufficiency of the complaint. That's all. The legal sufficiency of the complaint. So the question is, if we can look at the video in considering the complaint, then we would be considering the video as part of the allegations of the complaint.
Well, even with that, I believe that you're still looking at the video, and I think Doherty would still apply because when looking at the video, you still go back to the standard as to...
Well, your argument is the video doesn't show blatant inconsistency, and if that's so, then we're not allowed to consider it.
Well, you're not, because, well, my position is that if it doesn't show blatantly contradiction or utterly discredit, then the video cannot be considered at this stage. It's not saying the video can never be considered.
We're talking about a 12b-6.
That's correct.
And we're trying to understand the limits of it. And the question is whether the video was properly considered in disposing of the 12b-6. And the preliminary question is, it can be considered if it is part of the core allegations that's blatantly inconsistent. And you argue that's not so. It wasn't blatantly inconsistent.
Right.
And therefore, the court shouldn't have considered the video.
Correct.
Okay. My question to you is different. My question is whether your second amended complaint actually depends on the video because of the grounds that you filed gave the court to file the second amended complaint.
Well, our second amended complaint not necessarily depend on the video. We use the video to draft the second amended complaint, but not necessarily depending upon the video because there's a lot of facts and questions that's still there and the video doesn't resolve. So when you go back to
the video provides a lot of detail about what you're alleging. And I must say, I've looked at the video repeatedly, and I tried to stop thing, I don't know how to do that on the video, but it's hard to see. It's at night and everything's fast moving, and but I did see the video. Now, and the district court did, and the district court relied on it. So the real question is, if Doriotti didn't provide an inconsistency under Doriotti, then we shouldn't consider the video at all. And my first question to you was that we should consider the video when you stood up here this morning, and that we should consider the video. And I might agree with you, but then you seem to be arguing that we shouldn't have considered it because they didn't satisfy Doriotti.
Well, Your Honor, Judge Lieber, I think that I said that the courts could consider to the extent that it's not blatantly contradict allegation. But what Doherty is rooted from Scott versus Harris, you're talking about a case in the Supreme Court particularly, and that was at a summary judgment stage where the video was at issue in play, and the court said if the video blatantly contradicts the facts that's within the record, then the courts can look at light most favorable to the video opposed to the facts or the allegations made by the appellees or the appellate within that motion for summary judgment stage that went up to the Supreme Court. So even in Scott, a video in play, the courts, even at a summary judgment position, Supreme Court at a summary judgment issue said if the video does not blatantly contradict.
You're missing my question. My question is we're at the 12b6 stage. The procedure for converting it to summary judgment wasn't followed. And so, and the question is, why did the district court consider the video? And the reason the district court considered the video was because the second amended complaint, the whole complaint was filed based on the video, because that was the basis for your motion. We want to bring it in line with the video. And so that sort of invited the court to look at the video and said, our complaint, that's what our complaint is doing. And so the court looks at the video, and actually the court tried to follow Doriotti and said it was blatantly inconsistent, but I'm wondering whether that has to be satisfied at all in this case at all. And you say it does.
Correct.
And my question then is, how do we address your request? I don't know if it's your person, but your request to file a second amended complaint based on the video.
Even in Doherty, the Doherty relied on the video as well. In fact, both parties in Doherty cited to the video in their application. I actually with a lawyer in a complaint, as well as in the response to the motion dismissed by the appellees in that case. So even in that case, the court said both parties relied on the video. Even though reliance on the video in the complaint or in the response to the pleadings, if the video does not blatantly contradict the allegation, regardless of the reliance of the video, it does not get over that issue.
Well, if the video is authentic and is part of the complaint,
that's
if the
correct.
video is authentic and part of the complaint, it seems to me we read your complaint and we look at the video and we determine whether you've stated the cause of action.
Well, to the extent, I think you look at the video to the extent and you rely on the video if it blatantly contradicts.
No.
You know, even in the Doherty case, particularly when it got to the issue of qualified immunity, the Doherty case said because the argument rests on an improper construction of the facts and point in the proceedings, we declined to consider alternative argument because we was at a 12b6 standard, which is a less standard we were talking about plausibility.
All right, let me ask you a hypothetical then, and this is totally hypothetical, so we're not deciding the issue. Let's assume that the video is part of the complaint. Where do you take your case then? Don't you agree that the video gives you some difficulties?
No, I don't believe the video gives difficulties because, one, when you look at the video particularly, and you're talking about a Barnes versus Felix, and we're talking about totality of circumstances that came out after the Doherty case and before this case was decided by Judge Flanagan, we look at the totality of circumstances. The totality of circumstances, we're talking about 12 seconds where Mr. Selby was on the ground. And
I saw that, but then he got up and he started coming back at him. And no one knows where the knife was. And he's coming back at him on his all fours, and he's coming pretty quickly, and they shot him again.
Well,
so that, it seemed to me, we have a lot of cases where that type of threat is responded. And of course, the officer was entirely regretful he had to shoot. He tried to give him medical attention. He told him, keep breathing, keep breathing. He called the medics, and afterwards he's cussing at himself for having to use the gun. But the point was, there were two threats. The first one is when he told him to drop the knife and drop the knife, and instead of dropping, The man came at him with the knife in his hand, and he shot him, and he went to the ground. He's on his back for a while, and then he gets around on his thing, and he says, stay put, stay put. He keeps coming at him, and he shot him again. So my question is, you say the officer used excessive force in that case?
Yes. You look at the cases that's cited by the district court, Sigmund and Rampart. One, and you know, I'll say I'm running out of time. Can you allow me to finish that response? When you look at those cases, and you look at the facts in this case, one, it's disputed as to whether, well, I don't think it's disputed. I think it clearly shows that Mr. Selby did not have a knife on the 12 seconds. However, you continue to look at the video. You can look at Deputy Gibbs' body camera. Officer Glasser, Deputy Glasser, when Deputy Gibbs asked him, where's the knife? He goes over and goes to...
Yeah, but the guy who told the shot didn't, he kept saying, where's the knife, where's the knife? You couldn't see the knife. I tried to look at the knife when he got up from the ground. I couldn't see whether he had a knife.
Well, the shooter knew where the knife was at because he went right over...
He came out with a knife, clearly.
He came out with a knife...
And he came at him with the knife for the first shot, right?
Well, I disagree that he came at him. I think he came down the stairs, he missed the stair, and he immediately, he told him the knife, and he shot him.
He didn't drop the, two shots, right? I mean, two incidents. First is a shooting when he came down the stairs, and he was coming at him with the knife. He shot him. The plaintiff went to the ground, not the plaintiff, the deceased. Yeah, he went to the ground, and he's on his back, and he's complaining. Of course, he had a stab wound, too, which ultimately was probably the cause of death, but he was bleeding from a stab wound, and he's lying on the ground. And then he rectifies himself and starts coming up at him, and he's ordered to stop, and the guy shoots him again. And it turns out that put him down. Now, what killed him, that's another issue, but there were two provocations, so to speak. And my question is, which one did you think was inappropriate?
Well, it's argued that all shots was inappropriate. However, but the second and third shot, and the other corner asked that he was coming up, I think that's disputed as to whether he was coming at him. I think that you have a witness there. We're talking about that Mr. Shelby was trying to run between the officers. If you look at the video there at a 45-degree angle, and he's going in between. Actually,
he came down the stairs. He was ordered to drop the knife. He came down, he was standing still. He was ordered to drop the knife. After several orders, he came running down the stairs with the knife at the officer.
You know, we're talking about the second and third shot.
I'm talking about the first shot.
Well, when you asked me which ones, I said arguably all of them, particularly the second and third shot, clearly in an appellate's position.
Well, he's coming back at him again.
Well, I think that's disputed. And I think at this stage,
I saw it in the picture. He's on his hands, and he's coming up, and he's trying to rectify himself, and he's coming fast at the officer.
Well, you know, I think we agree to disagree in the position where he was coming towards him. I believe that the video show, you look at his video, that he was not coming towards him. Deputy Glasser was off to the 45-degree, and Deputy Gibbs was off to the right side of the 45-degree, and he was coming between. And in fact, he didn't really even get a chance to even go get up, particularly when the shots was fired. But the issue is, particularly when you're looking at a motion to dismiss stage, those are issues that's not utterly discredited. You only can look at it one way, and somebody else can look at it another way. That's why you go through discovery. In fact, in the Doherty case, when that case got remanded, the officer in that case, he testified that he shot Mr. Crenshaw and he was driving away. We would have never got to that in Doherty unless that case was remanded. This is the same issue here. We have a witness here on the scene. You're talking about ballistics. You're talking about experts. You're talking about pathology experts, which we utterly disagree that the cause of death was related to a stab wound, considering the evidence that pathologists have looked at it, we have not got to a chance to present. Well, Your Honor, that's the exact reason in Doherty why we reverse these cases. If it's not blatantly contradicted, utterly disregard, or utterly, the allegation are utterly discredit at a time why we should go through discovery. The question that Your Honor is asking, discovery should be go forth to determine as to whether the act was reasonable. At the motion dismiss stage, that's the standard, and I was asking this court to reverse remand and reserve some of my time for rebuttal. Thank you.
Yeah, you have rebuttal. We'll see you back on rebuttal. All right, thank you, Mr. Dennis. Mr. Haynes? Ms. Haynes.
Good morning. May it please the court. Sonny Haynes and my colleague Chris Geis on behalf of the defendant's appellees. The law allows the use of deadly force when a law enforcement
Let's
officer...
start in the beginning, though.
Yes, Your Honor.
we're at a 12B6 motion, and the district court considered the video. It wasn't made an exhibit to the complaint. It was the basis for the second amended complaint, I believe. The argument is that the video doesn't blatantly contradict the allegations of the complaint, and therefore should not have been considered. What's your response?
My response is what principally the video blatantly contradicts is plaintiff appellant's idea that Mr. Selby did not continue to pose an imminent threat. The imminent threat to Deputy Glazer as well as Sergeant Gibbs persisted.
That's a conclusion. That's not a factual allegation, right? So like, it's true, somebody needs to decide whether was he an imminent threat, right? But that's not a factual allegation that can be disputed, right? That's like saying, is it reasonable?
Well,
Right? Did he face an imminent threat? Like, that's the conclusion, right? The facts are, comes down the stairs, proceeds in this direction. Those are the facts. There's a knife, maybe the knife was put down, but those are the facts. It can't contradict the broad conclusion. It has to contradict the facts, no?
The predicate facts that support the conclusion that the imminent threats persisted until after the third round was fired are the fact that Mr. Glazer moved quickly down the stairs. The complaint reads, the second amendment complaint reads as if he proceeded down the stairs with his hands above his head. The video contradicts that because the key command that Mr. Selby ignored was
Does
to
the
drop the
complaint
knife.
say his hands were above his head? I don't remember that part.
It does. It says that he proceeded down the stairs with his arms raised. But the key part there is
Well, no,
that
but those are different, right? So I agree with you. If the complaint said he had his hands above his head, right? There's my head, my hands are above it, right? The video would contradict that allegation, right? But the question of whether my arms are raised, right? It is ambiguous, it seems like to me. Like, it's not that my arms are raised here, but my arms are also raised here, right? They're also raised here, right? So this is the rub I'm having, is like, what are the specific factual allegations that you think are blatantly contradicted?
Mr. Selby never dropped the the knife until after the first round was shot. So the second amendment complaint reads as if he was proceeding down the stairs in a calm manner, in a non-threatening manner, but what actually happened is that he did not drop the knife before he proceeded down the stairs. He proceeded down while holding the knife, which posed an imminent threat of harm to both Sergeant Gibbs and Deputy Glazer, which is why Deputy Glazer fired the first round. So that's what's blatantly contradicted, is the entire idea that he was not moving in a threatening manner towards the officers. In fact, throughout the whole very short
All right, but
exchange.
help me understand, I mean, I think this is hard, but I just want to make, and I'll stop after this. Where do you think the complaint alleges that he dropped the knife before he went down the stairs? So when
It said that he was unarmed, Your Honor. If I could,
where, like, tell me what paragraph you're looking at.
let me get you to the
11 and 12.
paragraph.
Right, so 11 says, put down the knife, he says, okay, and then it says he proceeded down the steps, right? He got
Correct.
another command to drop the knife.
And he did not.
Well, it doesn't say that.
It doesn't, but that's what the video shows, is that he did not drop the knife.
And so but that's not a blatant or your argument is that's the blatant, it's a contradiction by omission.
It goes back to your original question to plaintiff's counsel, which was if there are gaps, does the video fill in the gaps where the complaint is silent? It does, where those facts are relevant to the analysis here under Graham versus Connor and also the qualified immunity
Okay,
analysis.
so I understand that argument, but that's a distinct argument, right? That's distinct from saying there's a blatant contradiction, right? So it may be that we can consider it to fill gaps, but you said it blatantly contradicted the complaint. When I look at the complaint simply doesn't say whether when he came down the steps he had dropped the knife or not. It doesn't answer that question. And so maybe we, given the fact that he's continuing to get commands to drop the knife, maybe we infer that he actually still has the knife. I mean, that's the best read of what it's saying, is as he comes down the steps, if he's still getting commands to drop the knife, the natural implication is that the complaint actually agrees that he had the knife when he came down the steps.
Well, what the complaint says, I'm on 96 of the joint appendix. So Deputy Gibbs, paragraph 11 here. Deputy Gibbs gave a verbal command for Mr. Selby to put the knife down, to which Mr. Selby responded, okay. That is correct. I could hear him say okay in the video, but the key part there is that he did not drop the knife before advancing towards the officers. That is why those are the predicate facts that show that he continued to be
Well,
an
the
imminent threat.
sentence you'd have to rely on would be, while Mr. Selby's arms were raised, and within seconds of giving the command, he got shot. In other words, the idea is that he had thrown the knife down and he's raised his hands.
That is the idea, Your Honor, and that inference is not a reasonable inference when you look at the video, and it shows that he in fact did not drop the knife. We really don't know where the
Well,
knife
I don't think he
went.
raised his hands either from the video.
I agree with you there, Your Honor, but taking the complaint's allegations as they were drafted, that is what it says. And so he proceeded quickly towards the officers. He posed an imminent threat of harm with the knife in his hand to Sergeant Gibbs as well as Deputy Glazer. And then I want to go directly to those second and third shots, because the briefing from plaintiff's appellants really focuses on those and says that the court did not properly consider what facts were blatantly contradicted. And there, what you can see in the video is that despite the fact that he was told to stay down and to stop, he continued flailing his arms and he was pushing backwards. Now, the complaint characterizes that as an attempt to flee, but then also says that he was attempting to run between the officers. Well, you can't run between the officers and flee away from the officers at the same time. What the video shows, regardless of what his intent was, because we don't know what his intent was. Certainly Deputy Glazer and Sergeant Gibbs wouldn't have known what his intent was. We see him pushing his body back in Deputy Glazer's direction. That's not fleeing away, that's moving towards. Then he...
Well, actually, he flipped his body over. He was on his back, and he flipped over on a crawl, both hands and legs, and going at him.
That is correct.
Yeah.
And before he flipped over, he was pushing his body in the direction of Deputy Glazer. Then he flipped over, and when he was on the knees, you could see that his left hand is outstretched. Now, just as this court said in the Rambert versus City of Greenville case, the suspect continued to be a threat here because now Rambert is critical on this point. Rambert was not actually armed. We know Mr. Selby had just been previously armed. This is around midnight. It's dark outside. The only light is either coming from the officer's flashlights or the light that was at the door of the residence. So this is a dark situation. Everything's moving quickly, happening within 12 to 15 seconds. And when he flips over, he's got his left arm outstretched. We don't know whether he might be attempting to grab for Deputy Glazer's gun. We don't know whether he was attempting to go hands-on with the officer or whether he could have been moving towards Gibbs. Simultaneously, we have Sims there, who was the owner of the residence, who's also walking towards, saying don't shoot, but still walking towards, and there's a question in the dark about whether either of these individuals could have been armed at that point. And when Rambert said that even though Rambert was not armed, there was a known weapon, and it was Johnson, the officer's gun. Here we have 3 known weapons. The knife that he approached the door with, but then also the 2 officers' guns that either Sims or Mr. Selby could have been reaching for. And so Deputy Glazer's reaction to that, to protect himself as well as his fellow officer, was to continue to shoot because the threat had not subsided. And what this court's precedent has stated is that the use of deadly force continues to be permitted until the threat has subsided. And in this particular case, the threat was imminent until the last round was fired. And that is why the district court properly, considering the video, together with the allegations that were not contradicted by the video, correctly concluded that the defendant's motion to dismiss should have been granted on these facts. The district court was very careful about taking the plaintiff's allegations and crediting them where they were not contradicted by the video. So, for example, the court took plaintiff's allegation that there was blood on Mr. Selby's chest, and what the court said is, okay.
Well, that was pure for the video, too. I mean, he was wounded. I mean, there's,
Well, what's not clear is that the officers appreciated that, but the court said, we'll take a look at that. But the reason that it was really relevant there is because it actually, if Mr. Selby had just been involved in a knife fight or in an altercation, that would have heightened the potential threat to the officers. And I see I have 5 minutes left, so I'm going to turn it over to my colleague here to
Well,
talk about.
I think you have your, well, let me see.
Oh, is this my full 5 minutes? 15?
Yes.
You had
Okay.
15.
Okay.
Yeah.
Did you have a question, Your Honor?
No, that's all right.
Okay, so I'll keep going here.
Yeah, your light will be red, and then you can jump down or get a ticket.
Perfect, I'll look for the red. So here, where the court looked at the complaint's allegations, looked at where the video contradicted them, and then also looked at Graham versus Connor. And under the circumstances said that the officer, Deputy Glazer, was permitted to use deadly force under the circumstances because the imminent threat had not subsided until the last round was fired. Then she applied the qualified immunity test, and here, arguably, there's no constitutional violation. If you look at what this court said in Rambert, where the suspect was actually unarmed throughout the entire encounter with the officer, the court here said that the officer was permitted to use deadly force because there was an imminent threat that continued. The court here said the same thing in the Greenwich case, where the threat was assessed from the moment of force and that imminent danger justifies a shooting.
Can I ask you about some of the district court's descriptions or findings, maybe, from the video?
Please.
There were some things like the officer's flashlight shakes, and the court, said the ground was uneven, the officer tripped, everyone was in darkness, describing these and potentially factoring that into the analysis. The complaint doesn't say anything about that, and it might be a reasonable inference. I couldn't get a really good look at the ground to tell. Obviously the officer's camera is not looking at the ground, so those are inferences that have to be made. Was it appropriate for the court to be making inferences from the video that were not addressed by the complaint at this stage in the proceedings?
The court should, of course, take all reasonable inferences in the favor to the non-moving party, the plaintiff, but what I thought when I read that and looked at the video is that you could tell from the jumping of the camera that clearly something was impeding just a clear, steady view from the camera. So that's what I thought that inference was referring to. And then we also know that Sergeant Gibbs was backed against a utility trailer, so he did not have a clear line of retreat either because he had something behind him.
What about the officer's statements after the shooting? Not in the complaint, considered by the court, potentially exculpatory, but it's the sort of thing that it seems like there might be, discovery and depositions about, and, what did this mean, and why did you say this, and can we credit this, and, you can imagine all the arguments that would be made on one side or the other. Was the court correct to consider those and factor those into the analysis, and does your argument depend on it?
Our argument does not depend on it because even if you were to take those out of consideration and say that they were not dispositive, what we have is still a short, continuous encounter in the dark of night where the imminent threat continued to persist until after the first round was fired. So the fact that it was a good shoot and the court mentioned that, I do not think in any way that was dispositive to the court's decision. What was dispositive was what the video showed paired with the uncontradicted allegations of the complaint, the Graham versus Connor totality of the circumstances analysis, and then the application of the facts and the law to the qualified immunity analysis. So that is what was dispositive to the district court in granting the motion to dismiss. So briefly on the qualified immunity analysis, the court correctly considered that either prong under Saucier versus Katz, whether you consider that there was no constitutional violation or that there was no violation of a clearly established right, it's very clear here that there was no clearly established right that was violated under the circumstances. The officer, Deputy Glazer, Sergeant Gibbs, were faced with an imminent threat, and they were privileged to use deadly force in order to protect themselves under those particular circumstances, and the court correctly determined that. So again, with the federal claims, all of the state law claims rose and fell with the merits of the federal claims, and the court properly dismissed those as well.
All right, thank you. All right, Mr. Geis.
Thank you, Your Honor, and good morning, Your Honors, and may it please the court. First, sitting behind me are Deputy Glazer and Sergeant Gibbs, and they are the officers who responded to the scene. They did not know what they would encounter that night, and they had seconds to react to what they did, seconds to react to what unfolded. But that is what law enforcement officers deal with every day. It is why the applicable legal standard here comes from Graham versus Connor, which is what an objectively reasonable officer would do in that situation. And these officers, unlike us, do not have the luxury of what the case law has called armchair reflection.
Can you give me, I understand all of that. Can you help me understand what your view of the video is and what we can do with it? So much of the discussion of the Graham factors sort of feels like a summary judgment inquiry. And I totally understand that and can see how a summary judgment opinion could easily be written here. But we don't have that, right? And so we do have places where the district court sort of seems to go well beyond whatever we could think about using the video for. The sort of exculpatory statements after the shoot seems like the most obvious, but not the only examples. Help me understand how you think we have a complaint that doesn't expressly reference or incorporate the video, and except for a minute, hypothetically, that it doesn't blatantly contradict the allegations either, but it does obviously provide like really helpful context that sort of points out why there's probably like not a constitutional problem here. But I feel like that's a Rule 56 question, not a Rule 12 question. Help me sort of unravel that, can you?
Those are a lot of questions, Your Honor.
It was, I know, but you get the sense, right?
Yes, Your Honor. And I was going to discuss the clearly established prong of this issue and all the cases where officers had even mistakenly shot somebody. But I'm going to answer your question directly and with a little background on the history of this case. This complaint was filed only because the plaintiff watched the video, the plaintiff and the plaintiff's attorney. They don't know what happened except what they saw in the video. When they filed the second amended complaint, they said we wanted to track the video. So there should be no issue in this court about whether or not the video is properly before the court. It is. The plaintiff admitted that. And when they filed the complaint, actually they said the video tracks play by play exactly what happened, or the complaint tracks play by play like our transcript in real time what happens on the video. And that's demonstrably not true. For example, when if you look at what Judge Niemeyer said about Mr. Selby's hands being raised above his head, the strong implication there is that this man is surrendering. And if you shoot a man who's surrendering with his hands above his head, that is blatantly unconstitutional and unlawful.
I understand, but your colleague on the other side is a better lawyer than you're giving him credit for, right? He doesn't say the hands were above the head, right? He says the hands were raised. And that's a little bit ambiguous.
He does in the briefing.
Well, but all I get to look at, I think, is the complaint. I totally understand the argument you're making, right? But the complaint doesn't say that.
Well, Your Honor, years ago, before videos were readily available, we pieced together what happened through deposition transcripts, affidavits, medical records, photographs, and other evidence. And in numerous cases, and I can give you a list of them, the court found that the officer was entitled to qualified immunity or there was no unreasonable use of force. And someone always said in those cases, if only there was a video to show us what really happened. Well, you have that here. You have objective.
But in all those are Rule 56 cases, right? So none of the things that you mentioned were ever being considered at the Rule 12 stage, right? All of that discussion, I totally get you. I am sympathetic at Rule 56. right? But the very example you give highlights that all of those things are being decided at the Rule 56 stage.
Your Honor, you have objective truth in front of you about what happened. A plaintiff should not be able to distort the facts based on the plaintiff's perception of reality to overcome objective truth. And that's what this case is. That's what happened in Scott v. Harris as well. Justice Scalia said, look, you can say whatever you want. You can say it's Tuesday when it's really Wednesday. We're going to look at the video and determine that it's Wednesday. And I see I'm running out of time here, Your Honor.
You can finish your answer, Tim.
And the court said in Scott v. Harris, we can look at what actually happened. We don't have to listen to what the plaintiff says happened. And you've got numerous factual inaccuracies, misleading assertions, and other things, and that is not entitled to deference, even at the Rule 12b-6 stage, especially when the complaint was drafted based only on the video. Does that answer your question, Your Honor?
It does. Thank you.
All right, thank you.
Thank you, Your Honors.
All right, Mr. Daniels.
Your Honors, I would like to point this court to JA 95, Joint Appendix 95, and particularly paragraph 9. It said, upon arriving to the residence, Mrs. Selby, who was suffering from a stab wound to the heart, was ordered by officers to exit the residence. Notably, Officer Gibbs was closer to the door and did not unholster his service weapon. Your Honor, the district court pointed in footnote 5, which is JA 134, and said that the fact that the plaintiff said that the officer first ordered Mrs. Selby out of the home, that was contradiction to look at the video. In fact, the complaint never said anything about first. The district court added the word first. And the district court going to say that other video citations similar contradict allegations in the complaint. Does not point to one other contradiction within the district court's order whatsoever.
All right, so what about this one? So I think I'm just mistaken, because when I went back to try to find, I did a search for the word above his head, and you do allege on JA 93 that Shelby was initially shot by Glazer with his arms raised above his head. Like that, I mean, I've seen the video, like that seems blatantly false.
Well,
Do you think, just, you've seen the videos more times than I have. Is there any way to interpret the video that his arms were above his head when he was shot the first time?
Well, I believe that the standard as to whether, to answer Your Honor's question, as to whether it utterly discredit, or blatantly contradicts, is, I think the video showed his arms was raised to the extent that it was raised well above his head. I think that's...
No, not well above his head. I'm asking the question, right? I mean, we've got the video. We'll put the still shot in, right? It's not hard. Is there any argument that he was initially shot with his arms raised above his head?
I don't believe his arm was raised above his head. I believe his arm
Right.
was...
So that is an example that is like blatantly false based on the video. Or to say it more directly, the video blatantly contradicts that allegation.
I think an argument could be made, but I don't think that...
No, I think you've effectively agreed that like the video doesn't show that to be true.
Well, Your Honor, I think that the video shows that his arm was raised to the extent it was raised above his head. They're not actually raised well above his head.
I don't think they're raised at all. He's coming at him, he's running at him with something in his hand. There's no suggestion that he's raising his hands. Your suggestion when somebody raises his hands is a surrender motion.
No, I'm not.
There's no surrender motion. And you also allege that after the first shot, he was getting up and fleeing away from the officers. And you allege that he was shot while he was fleeing. And the fact of the video shows that he was shot when he was coming at the officer.
Your Honor, we do not argue in our allegation that he was fleeing when he first was coming down the stairs.
No, you use the word, this is, there's two incidents here. First shot is when he's coming down the stairs, he had the knife in his hand. And that was, all the officers saw the knife. And he was coming at him, and he was shot. He went to the ground, fell on his back. He recovered and got on his front fours and continued coming in the same direction he was coming down the stairs at the officers. and he was shot twice more. And that's what the video shows. You allege he was shot first when he had his hands raised. You didn't say above his head. You said that in the initial introduction. He was raised above his head.
Raised.
And then you said he was shot the second time when he was trying to flee. He got up in force and tried to flee the officers. And he wasn't trying to flee in the video.
Well, Your Honor, I think that's an interpretation that.
It's not an interpretation, it's you
Well,
allege.
I think it's an argument that a reasonable jury can conclude differently, especially when you have a witness on the scene, Mr. Sims, who we believe is going to testify he was in fact trying to run away. That's the same issue that was argued in Doherty, particularly as to
I'm
whether.
just looking at the, without anybody's testimony, just looking at the video, objectively, he was trying to get up and moving in the direction of the officer, the same direction he was moving when he was coming down the stairs. He fell on his back, righted himself after you said 12 seconds, whatever, 11 seconds, 12. He was getting up on his, and then he got up on his hands and knees and started sort of running or crawling fast toward the officer again.
You know, I respectfully disagree of the description that he was coming towards the officer. I think the video
In the
shows.
same direction, the same route.
And I understand the officer was standing in a one direction, but he was coming towards this direction. The officer standing in a 45-degree off to the side. He was not coming directly at the officer. And that's the same argument that was made in the Doherty versus Slayton, that he was driving towards the officer. But once we got to the discovery, and I think that's why it's important.
So what are you going to rely on a discovery that showed something different from the video?
Well, one, we don't have the officer testimony. We don't have the officer testimony as to what he believed. That's one thing. Also, you're talking about another witness.
Of course, what he believed doesn't matter, does it?
It doesn't matter.
It's objectively what he was confronting.
But I think it goes a long way as to whether what happened, what he saw, perceived as well. You have another witness. We're talking about experts' trajectory as to where the bullets, what direction the bullets came in. They clearly went in from back to front. Where the bullets went into his body. Those are evidentiary things that should be determined on a motion for summary judgment, not at 12b6.
When we're dealing with, sort of the two prongs here, we have, was there a constitutional violation and was it clearly established? It would seem to me that we can all agree the decedent moved in the general direction of the officers before the second and third shot. Does it even matter whether he lunged directly at them, lunged toward them, lunged 45-degree angle near them, when we're talking about these sorts of split-second decisions? Do you think it sounds like maybe you do, but do you think it's going to make a constitutional difference whether he was coming, directly at or at a 45-degree angle between the officers who were telling him stop?
That's a great question, Judge Rush. And I think that the moment of threat doctrine has been reversed by the Supreme Court.
Yeah, the Supreme Court has said you have to look at the entire situation, which is presumably why we're talking about the first shot, because you don't dispute that one in your brief. But you have to look at the whole situation. But, obviously, the moment they fire the weapon is the moment at which they must have fear that the suspect is going to injure them or someone else.
Well, I think when you look at the totality of circumstances, particularly as the 12 seconds that Mr. Shelby's on the ground showing his hands, and the fact that you continue to look at the video, if the courts looked at the remaining video, particularly when Mr. Deputy Glasser asked Deputy Gibbs asked where's the knife, Deputy Glasser goes right to it. The inference that he knew exactly that the knife was by the stairs. And
So sorry, to come back to my question, your argument is there is a constitutional difference, even a clearly established constitutional difference that's going to make or break this case based on whether he was coming directly or at a 45-degree angle toward the officers. I mean, the video shows him coming toward, and your argument is just like not directly in his face.
I think yes, Your Honor, I think if we look at this case, particularly in the lens of Tennessee versus Gardner, where you can shoot a fleeing suspect, and we have a witness there that we haven't even reached at this point, Mr. Sims, in this matter, as to give direction to the district court as to what direction, what Mr. Shelby was doing at that time, regardless of the officer's position, what he thought. We have another witness there that says Mr. Shelby was trying to get up and get away. He was trying to get away. So that's something that the court should consider at a Rule 56 summary judgment. But we're talking about a motion to dismiss stage, and the same issues that's presented before this court was presented in Doherty as whether the plaintiffs relied on the video. But the courts in Doherty clearly said that even if the courts can consider the video to the extent that is blatantly contradicts or other discredited allegation in this case. We
Did
believe
you
that
attach some photographs to some of your papers before the second amended complaint? On your first memorandum, all the documents are not here in the JA, and I would like to look at them, but in your defense of the first complaint, did you attach some pictures?
Your Honor, I don't believe that we attached pictures. I don't necessarily remember as what picture was attached, but I don't think picture was attached.
The court
to make.
said something in a footnote about some pictures being attached, 3 pictures.
I think, I don't recall if we actually attached pictures. You can point me to what footnote you're referring to.
That was when the court granted the motion to amend. They were referring to well, I don't have that here, but I'll take a look at it.
But to the extent, excuse me, to the extent if the complaint, I think Judge Richardson point, the complaint does not rely on the video. The plaintiffs, we looked at the video and drafted the complaint as we looked at it, but it doesn't have reliance on the video because we believe obviously it's more is needed, particularly not just a video alone. So when and I get back to this thing, this is an A and B argument. Before you get to B, before we talk about Graham, Connor, we talk about reasonable constitution, was it clearly established? The Doherty court has already said you cannot get to that if there's no blatantly contradiction. You cannot get to that if there's no utterly discredit. And that court, even when the arguments made, say you can't reach that. And the fact that Your Honor believed that the plaintiff's complaint relied on it, that's the same argument that the Doherty court, if you relied upon it, can it be considered? And the court said no to the extent if it does not blatantly contradict. We ask this court to reverse and remand not only the qualified immunity issue as well as the public immunity, as this court didn't really address that issue.
Thank you, Mr.
Thank you.
All right, we'll come down and greet counsel and proceed on the last case. All right, next case we'll hear this morning is Bacardi versus Coke Stewart, and Mr. Zions will hear from you.
Thank you, Your Honor. Good morning, and may it please the Court. David Zions on behalf of Bacardi. Cuba Export's renewal payment was due in 2006. It couldn't make that payment until 2016. That's a problem under a time-oriented statute.
Well, it made the payment, and the payment was received and accepted for 6 months and then returned.
Your Honor, if you look at JA 242, which shows the record of what happened, you see there is a payment. The first line there is a payment that is dated January 2016 that is for the 2006 renewal. There was a separate payment attempt that is marked as reversed. So Cuba Export made it unlawful.
I know it was reversed, but the point is the money was actually dispensed several months from the account and then refunded. Yes. But I notice you make arguments several times that the payment was never made. It was made and refunded because the assertion was that there wasn't a license to receive it.
Sure, and so that attempt
and
to
there was
make
an appeal taken from that.
Yes, Your Honor, and what as I take the government's brief, they say essentially they were correcting an error that it should have been accepted. That's not what the director actually said. The director said that what the examiner was constrained to refuse the filing. So, payment was attempted, it was proffered, it was illegal. If I went to the store and handed the cashier $5 for...
But that was appealed, right?
It was appealed, Your
The
Honor.
denial was appealed.
Yes.
And a denial was made on the failure to receive the payment, and the payment was denied because there was no license.
The payment was
Refunded.
was refused. It was not accepted.
It was refunded.
Yes.
All right,
Yes.
it's a difference. Let's keep it all straight. An appeal was taken from that, and that appeal was pending for 10 years.
Correct, Your Honor.
And on appeal, ultimately, the court reversed that and said the license has now been applicable, and the payment is received, and the question is, what's wrong with that?
Sure, Your Honor, there's a lot of things wrong with that. One thing that is wrong with it is that the OFAC license didn't actually authorize that payment to be, to the extent there was any payment at all. It didn't authorize a retroactive payment. It said you can engage in payments, engage
Well,
as a
the law
present tense
changed in
word.
between. The law changed while the appeal was pending, and the appeal then gave effect to the change in the law.
Your Honor, a couple points on that. The change in the law was the license. So the law only
Yeah.
changed in a way that enabled this decision if you read the license as retroactive, and you have basically a clear statement rule in the OFAC regulations that you have to be really clear.
I'm not
that it's
understanding the
retroactive.
license was retroactive. I'm suggesting that the license was allowed because of a change in governmental policy. And so the license is given in, 2016?
Right.
And so now the appellate agency, the director, says, okay, now that they got the license, the initial application is granted, reversing the original determination.
Right. So you go back to the Lanham Act. The Lanham Act creates a 10-year term for registration. So you have to do certain things by certain dates. You have till the end of the registration period, that was 2006, to effect a payment.
They did it timely. They did it in 2006. That was timely, wasn't it?
If it had been lawful and effective, it would have been timely, but it wasn't.
Well, that's subject to appeal. The director could reverse that, right? Just like in a district court and an
Yes.
appellate court. The district court does one thing, the appellate court reverses it. It's effective as when the district court operated on it.
So, if, there's a number of issues here. One is the retroactivity of the license. If this is not a retroactive license, I don't think that changes the law as it existed at the time that the payment was due. If this is not a retroactive license.
The director approved the license in 2016. That was applied for in 2005, right?
No, Your Honor, there was the
I
license.
thought that's what he said in the opinion.
If he said that in his opinion, then it is directly contradicted by the record. In 2005, there was an attempt to pay. There was reliance on a license that was not actually
You keep saying an
authorization.
attempt to pay. There was an application to renew a trademark, and there was a payment made, and the payment was received. It turned out during the next several months that they didn't have a license. They determined they didn't have a license to receive that money. The money was refunded, and the application was denied. An appeal was taken. That leaves it open, doesn't it, when the appeal's taken?
Well, Your Honor, part of the issue here, and I want to just get back to this factual point, there was a license that was applied for in 2006 that was denied in 2006. Then there wasn't even a license application pending until I believe it was November.
What was appealed?
Of 2015.
So the license, just to make a little clarity here, the license refers to something from OFAC.
Correct, Your Honor.
Right? The registration refers to something from the Patent Office.
Correct, Your Honor.
And so OFAC has licenses, Patent Office has registration.
Exactly. That's
So
exactly.
what was appealed was the registration,
Yes.
not the OFAC license, although that may have also been
That was
appealed,
also
but-
separately appealed,
But what
but-
we're talking about goes to the director is not a license, but instead a registration.
That's exactly right, Your Honor. So, and this is, even if Your Honor doesn't think that there's a contrary.
But the issue in this case is the registration, the renewal, right?
Yes,
Okay, so the registration is appealed,
yes.
and the commissioner, or the director,
Yep.
approves the registration in 2016.
Yes.
On appeal.
Yes.
So what's the issue?
Your Honor, there's a lot of issues. I won't
I
belabor
know,
the
but tell me
OFAC
what's
license.
wrong with the commissioner's or the director's decision.
Okay, well, the Lanham Act sets deadlines. It sets, the whole point of this statute is to get Deadwood off the register.
Can we talk just for a second about the statute?
Sure.
Just to help me understand it a little bit?
Yes.
So I look at 1059A, and the part that's sort of relevant here is that there's a deficiency.
Yes.
So in December of '05, there was an application filed, there was a deficiency, the office action the following summer then effectively says, you got to fix this deficiency.
Yes.
That's the payment, within 6 months.
Yes.
All right. So then there's an appeal to the director.
Yes.
And I presume you agree at that point, the 6-month deadline is effectively stayed because it's now been appealed.
Your Honor, there is a separate regulation that says that petitions to the director don't stay your deadlines absent.
But for the
absent a
time
specific
prescribed,
decision.
right? It's odd to think about the time prescribed because then that would mean if you take an appeal, you cannot ever satisfy the deficiency, right? That would be an odd result. So you think the office action says you got to do this within 6 months, right? That's the time prescribed.
Yes, Your Honor.
It then goes to the director, and the director comes back and says at J466, I'm suspending this action and presumably the deadlines that go with it until, he doesn't say this, but until 2012.
Yeah, well, Your Honor, I agree with a lot of that. I don't think the director suspended any debt, said.
So your view is that in December of 2006,
yes,
despite the ongoing appeal, the Cubex board had to pay the fee as the lower level person had suggested, regardless of the fact that the director had the matter. And if they didn't pay it by the end of 2006, it was forever cut off, and the appeal was then moot.
Well, no, so our position is it's not just the office action that set the 6-month deadline. There is a regulation
That
set
regulation
the 6
doesn't
months.
remotely apply. So, except hypothetically
Okay.
that regulation is totally irrelevant.
Okay.
All right, just hypothetically accept it for me. All right, so the question is, the office action says do it in 6 months, but you can appeal, and they appeal. It can't be that you're arguing they still had to do it in 6 months, even though the director had the action.
The appeal wasn't about the time.
It was about the deficiency.
It's about whether there was a deficiency, right? Because they want to come back and say, in fact, one of the challenges that they bring is OFAC's got this all wrong, right? We don't really need this license works, right? That's all about whether the payment should have been rejected or not.
Yeah, and that is all fair, and I don't think that.
But on appeal, 2 years later, beyond the 6 months, 2 years later, the director could say there was no deficiency, and the registration is accepted. That would be appropriate, right?
Yes, Your Honor.
If here's 10 years later, and he says the registration's appropriate.
Because the director, essentially here, the delay was part and parcel of the decision. This trademark registrations are supposed to expire. What you have here is essentially a pocket veto of the way the Lanham Act is supposed to work.
There's a cause of action for delay, right? If an agency is not acting within what you think is an appropriate amount of time, you can bring a cause of action for delayed decisions, right? But now there's been a decision.
Right.
So there's no longer a cause of action for delay. Now we're here talking about the decision that was made and whether there was authority to make it and whether it was arbitrary and capricious, right?
Yes, Your Honor. I think a delay can be relevant to the question, separate from a cause of action, which, as Your Honor knows, is very difficult.
Well, you're looking for something in the regulations or somewhere that says the director doesn't have the authority to take a really, really long time to decide.
Or at a minimum, it's arbitrary and capricious. So to take Judge Niemeyer's point that the law changed while this petition was pending there, the only reason that happened is because of this completely unexplained and extraordinary delay that lasted the entirety of the term of the trademark registration from 2006 to 2016.
But that happens in litigation. Somebody files a cause of action 3 days before the limitations run out, and the district court dismisses it and said, oh, the 3 days, you didn't calculate it right. They appeal, And the Fourth Circuit says, no, it was timely. And we don't decide that for 3 years later. We're still deciding what happened at the time by the district court. And we send it back and they can try the case, even though it's 3 years beyond the statute of limitations now, because we made our decision 3 years later. Here, the director made his decision 10 years later, but it was appealed, the deficiency was removed, and the registration was approved.
Sure, Your Honor, and I think, I just go to the basics of reasoned decision-making. Even if you accept, Judge Rushing said the issues are authority and then, discretion and how that was exercised. Even if you accept that there was discretion to do this, that it was okay, to wait this long, it was okay to treat this as, to set this time period for correcting the deficiency, accepting Judge Richardson that the regulation didn't mandate a 6-month period, it could be longer. What the agency has to do is explain what it is doing and why it is doing it.
So help me understand that. So why is it, so Bacardi didn't file the APA action for a delayed decision?
That's correct.
Right. Okay.
Yeah.
And so why is it that the agency has to explain the delay when it makes the final decision? If you had challenged the delay, they would have had to explain the delay. That's fine. But we don't say that every final decision of the agency must articulate the reasons for every procedural step that took place before the final decision. I guess I don't understand how you think the agency was required to explain the delay when the delay had not been challenged. We got a final decision, they explained the final decision. You may think the final decision's wrong. I totally get that, right? And there are arguments to be had there. But this argument about the delay doesn't seem to be pertinent because you didn't challenge the delay. You've challenged the final agency action.
Sure, and I would just say, throughout this time period, every signal that one could get from the agency was that it had no discretion. This will be deemed canceled / expired, and so that's the explanation. But accepting even if Your Honor doesn't think that they needed to explain the delay, what they at least needed to explain, why did they get 10 years to secure the deficiency? The director could have decided, on the hypothesis that this is
Isn't that just saying they had to explain the delay? Why did they get 10 years to secure the deficiency? That's simply just recasting. You think they had to explain every procedural step along the way.
If there is discretion here, I don't think that's a procedural step, and that maybe that's the important point. It's statutory. The time prescribed after notification of the deficiency.
Who do you think gets to decide the time prescribed? Who is the decision maker? The agency. And it's within their discretion. I understand you have this argument about the inapplicable regulation, but we're hypothetically assuming that it's totally inapplicable. All right. So, but in that world, right, the agency is the one that has the discretion to decide.
The agency has discretion, and the basic rule of reasoned decision-making under the APA is it has to explain why it's exercising that discretion. Here, if
that discretion is challenged, but not if some final decision is made. That's the rub I'm having. If you had challenged the delay, I totally get it, right? Unreasonably delayed adjudication, it's almost impossible to bring. I understand that, but they would have had to explain themselves. But why do they have to explain themselves in the final adjudication?
I don't think what I'm saying here is they had to explain the delay. If what happened here is they were granting, accepting, Your Honor, that the director can say, I have discretion to decide what is the time to cure the deficiency.
They were granting the application filed in 2005 for registration. So that registration application was timely. And they just granted it after a long delay on appeal. And I don't see procedurally why that's a problem except the delay period. Now, I tell you, I do wonder, and I might as well ask you this question. It seems to me like we're dealing with stolen property, and I can't understand why they get any rights at all based on the confiscation. Now, is that something in some other litigation? How did they get a trademark in 1976 in the first place? That's strange, isn't it?
Yes, Your Honor. One of the claims in separate litigation is that they got that by lying to the PTO. And
is that being litigated?
That has been litigated very, very slowly. It is now currently being stayed. There's a lot, there's a lot here, Your Honor.
I mean, when I start reading this record, and we have a confiscation of property and along with the goodwill and the trademarks. And you guys got your trademark from that original owner.
Yes, Your Honor.
It seems to me Cuba Export got nothing. This is just intuitive based on those facts, and I was wondering, why are we litigating this at all if Cuba Export never had title? I mean, it was stolen, so to speak. It's like trying to acquire property to a stolen Thunderbird and asserting rights on it.
Yeah. Judge Niemeyer, there could be a very long answer to that question. I'll just give you the very short answer, which is there's a lot of problems here. Is
that still open, that issue that I just asked about?
Yes, Your Honor.
Oh, okay.
Can I ask a follow-up question about the arbitrary and capricious review?
Yes.
It seemed your discussion with Judge Richardson was about explaining, maybe the director has to explain why she's granting so long to correct a deficiency.
Yes, Your Honor.
And you're distinguishing that from the delay. But then Judge Niemeyer pointed out, well, the director had two bases for her decision.
Right.
The alternative secondary description was that there was a deficiency at the time that needed to be corrected later. But her first reason was that actually at the time, that was the wrong, in retrospect now we know that was the wrong decision at the time, that the payment was made timely and now it is being accepted because now there's an OFAC license for it. So does your explanation about the arbitrary and capricious explanation by the agency apply to that first reason at all when there's no deficiency to correct?
It does, Your Honor.
How?
It's a different arbitrary and capricious argument. It's not about the decision. The point I was making to Judge Richardson is the decision to set effectively a 10-year period as the time prescribed.
Right. As opposed to 9 or 11 or whatever.
9 or whatever. It's a slightly different problem. So what the agency says, this is all about reasoned decision-making. The agency is invoking the authority to exercise supervisory authority in appropriate circumstances. Usually, the agency says that's because the examiner made a clear error. Here, the director says in her decision, no error. The examiner was constrained to act as she did. Nonetheless, the circumstances are appropriate for me to exercise supervisory authority. That was not compelled there's no scenario in which the director's hands were tied in 2016 to do that. The director could have said...
Sorry, I thought you were going to tell me why that explanation is arbitrary and capricious.
Because there was, Your Honor, I don't think there was an explanation. It just said, it's appropriate to exercise my supervisory authority. OFAC has produced
Now we have
a
an OFAC license.
It's been paid. And there's a whole host of policy questions about why that's a good reason. Why should the director have exercised supervisory authority here? There is a hypothetical world where Cuba Export had been a little more honest about what the state of the law and the state of the license was in 2006, and had just told the PTO, I'm not going to make this unlawful attempt to pay. I'm just going to tell you, unfortunately, I don't have a license, and I'll let you know when I do, you should grant this anyway. In that world, there wouldn't have been the payment that was
They did have a license of a different ilk, and they thought that license was appropriate at the time. The license was to the firm, the law firm,
Right.
and the determination was made later. No, you had to have a license to pay for the United States to receive that, and it's not as if it's day one. Everybody knew it was illegal. It was determined to be deficient, and that was reversed by the director.
And Your Honor, if the director had made that decision, I've thought about this, and I think everyone was operating in good faith. And actually, this is something that happens in a lot of the cases that the PTO says. The director often says, I think someone made a mistake here, but it was in good faith. Everyone was trying their best, and that's why I'm going to exercise supervisory authority. The part of the problem here is if there was discretion on the director acted like she didn't have discretion. It's just, it's 10 years later, now there's a license, what are you going to do? My hands are tied.
So why isn't this analogous, you've been here all day, but why isn't this analogous to our first case, right? So the district court judge issues a decision, so the office action here issues a decision, and at the time it was made, it was totally reasonable, right? But while it remained on direct review, the Supreme Court issued a different decision. Read OFAC issued a different decision. And so we now have the case, and we say, listen, like, we now have to apply the Supreme Court. And the director says, well, listen, I have to apply OFAC, right? That doesn't seem like, that seems like an obvious idea. And so I guess I'm having a little bit of trouble understanding why you think the explanation given isn't sufficient, right? So there was a ruling one way, OFAC changed its mind, like we're effectively on direct appeal. Of course, you've got to apply the OFAC ruling that applies now.
Sure. Well, I think, one way that this is different from what happened in the scenario, in the judicial setting, there's a hierarchy. There's district court, court of appeals, Supreme Court. Here you have PTO over here and OFAC over here. It's not.
But everybody agrees with respect to the payment, OFAC's decision controls, right? The PTO can't say, screw you, OFAC, right? Like, in the same way the Supreme Court controls us, OFAC controls payment. PTO can't thumb its nose at OFAC on that issue.
It can't control whether there is a license. What it can do and what it has to do is decide, does that meet the requirements of the Lanham Act? The Lanham Act says you have to pay by a particular time. And OFAC has this license. I think you have to then look at the license. Does it apply retroactively? If it doesn't apply retroactively, then all you have is an authorization to make a new payment. And then maybe the director should at that point exercise discretionary authority to set a 10-year cure period, but now we're into the second issue.
The second is not the first issue. I understand. Thank you.
Okay.
Thank you, Your Honors.
Yeah. All right, Mr. Shaw.
May it please the Court, Whaley Shaw for the PTO. OFAC determined in 2016 that as a matter of U.S. foreign policy, Cuba Export should be allowed to engage in all transactions necessary to renew its trademark, including the payment that Cuba Export had made in 2005. Now, in light of that license and with all the required fees in hand, the director correctly determined that Cuba Export's registration should be renewed, and the director gave two rationales. The principal rationale was that because the license retroactively validated the 2005 payment, and that payment was the lack of a license for that payment was the only reason for the denial of an otherwise complete application, the director was now obligated to grant the renewal, accept the payment. The alternative rationale was that by providing payment in 2016 based on the new license, Cuba Export corrected any deficiency in the original application. Now, this court can affirm on either ground, but I would like to start with the principal rationale, which is the retroactive validation of the 2005 payment. Now, that 2005 payment went through three different stages. First, as Your Honor identified, first it was accepted and posted to Cuba Export's accounts, and that's where the funds stayed for actually I think it was about 8 months, including through the expiration date of, or the original expiration date of Cuba Export's registration. Then an examiner decided that the payment was unauthorized and should be rejected, and then finally the director reversed that decision and decided that the payment was valid based on the new OFAC license and that the payment should be accepted. Now, Bacardi offers no reason to treat only the second of these three decisions as the sort of determinative or binding decision. If the examiner could wipe out Cuba Export's original payment by refunding it, then Cuba Export in turn wiped out the effect of that refund by refunding the refund, if that makes sense. Similarly, if the examiner could reverse the agency's original acceptance of the payment, then the director could reverse the examiner's rejection of that original payment. And that's contrary to bedrock principles of administrative law. Those principles tell us that it is the director that exercises final authority on behalf of the agency to decide whether or not to accept a payment, to decide whether or not to renew a registration, and it is only the director's decision that is on judicial review before this court. Bacardi's contrary interpretation would create all sorts of absurd circumstances. It would mean, for example, that if the agency, for example, either because of a bureaucratic delay just didn't withdraw the funds in time, or maybe the examiner just made an error and refunded the payment wrongly, that the applicant would now be completely disabled from making a timely payment, and in fact could lose their registration for an error that was not of their own making and that was entirely due to the PTO. That would be like if you send your credit card company a payment and then some junior person at the bank erroneously sends your payment back. Then the credit card company comes to you and says, well, you owe us a late fee and interest because you didn't make your credit card payment on time. You would be justifiably upset about that because the sort of the return of the funds is entirely an error on the bank's part and not yours.
They're going to point out that they did, right, that CubeExport did pay a late fee, right? What's your argument to that?
Yes, I'm happy to address that. So as I was saying earlier, the director offered two rationales, a principal rationale, which was the retroactive validation, which did not require the deficiency surcharge, and then also a sort of secondary or alternative rationale, which is that CubeExport corrected the deficiency in its application. And if that rationale is correct, then CubeExport was required to pay a $100 deficiency surcharge. Now, the agency sort of withdrew the higher of those two fees, but you know that the fact that the agency withdrew the higher amount doesn't mean that the underlying decision was invalid. Obviously, you know, if this court were to affirm on the principal rationale, maybe CubeExport could argue that they were overcharged by $100, but they haven't made that argument, and it's not presented before this court. It's also not a reason to overturn the decision of the director.
Is there any limit, in your view, is there any limit on the director's ability to sort of like sit on these things? I mean, it seems fairly obvious that there was sort of a policy decision to sit, and maybe you want to fight the hypothetical, but except hypothetically, there was a policy decision to sit on this because we were in a time of significant change with respect to the United States' policy toward Cuba, and maybe this was one of the bargaining chips that were on the table. Is there any limit on that? I mean, it seems odd to have the scenario where the director can sit on an application for longer than the period that is being sought, right? I mean, I understand generally we think like there's pretty broad discretion in the time, but my goodness.
Right. I mean, certainly a very long stay of proceedings is possible both in agency proceedings and all sorts of judicial proceedings. And there are sort of ultimate limits on that sort of discretion. For example, as Judge Rushing pointed out, there is a kind of action called a track action in which someone can ask for a court for a writ of mandamus to direct that an agency take action that is unreasonably.
We get this type of claim we've had it several times now, we've written on it, but a lot of the statutes say that if the director doesn't act within so many days, he's deemed to have denied the appeal. I gather that's not in the Lanham Act.
Right. There is no such limit in the statutes here, and in fact, it's sort of the opposite. And the Congress expressly gave the director the discretion to prescribe, and now I'm speaking specifically to the second rationale. Congress expressly gave the director the power to prescribe how long an applicant should have to correct a deficiency in an application, and Congress did not set any limits on the exercise of that discretion. So to sort of for Bacardi to come in and
but they did. So the office action set a deadline. The office action says you got to cure this within 6 months. Why do you think the appeal sort of effectively suspended or stayed that deadline? Right? I mean, the office action gave a time prescribed to cure the deficiency. I understand we're only in this second rationale bucket. Why did the appeal to the director change that? I mean, your colleague points to the statute that says, deadlines don't go away because of a appeal to the director.
Right, because as I was saying, Congress gave the agency, whose powers are vested in the director, the power to prescribe a deadline for correcting deficiencies. Now, the examiner set a 6-month deadline, and in fact, that's what they're supposed to do under the trademark manual of examining procedure. But the examiner is not the ultimate authority, doesn't have the final authority to act for the agency. That's the director, and the director can obviously change the deadline that's been prescribed by an examiner, and that's what happened in this case. And if the director didn't have that authority...
And what is, the director did that by virtue of what? Do you think that the 6-month deadline was effectively stayed by virtue of the filing of the appeal? by virtue of the suspension of the process, right, pending this, other proceedings that don't end until 2012, or by the final decision? Which of those do you think changed the office action 6-month deadline?
I think the best way to think about it is that the director, by accepting the correction, is implicitly extending the deadline to allow that correction.
Retroactively.
Yes, and I think that it has to be the case that the director has that authority, because otherwise, by the time the case reaches the director, that 6-month deadline is always going to have expired.
Sounds to me like the director implicitly reversed the deadline by accepting the registration 10 years late.
I think that's.
Or the payment 10 years late.
Yes, I think that's correct. Certainly correct for the second rationale that yes, the director implicitly reversed the deadline that had been given by the examiner and then allowed a longer deadline, which allowed Cuba Export to cure.
What would have
correct
happened
deficiency.
if there had been no appeal taken to the director? Would the office action then have been final?
Yes, if there was no appeal to the director, then I think the PTO regulations require that the registration be canceled or expired, and so we wouldn't.
That takes me to my big question. Why are we dealing with Cuba Export registration? I mean, every time they renew, it seems to me it should bring up the question of who's the proper owner of the trademark.
Yeah, to be honest, I am not, this is a large and sprawling litigation, and I'm not fully up to speed on those aspects of the case. Obviously, that is being litigated. There have been proceedings before the PTO, before OFAC, and district court. There's a cancellation proceeding where Cuba Export is trying to cancel, Bacardi is trying to cancel Cuba Export's registration to the Havana Club mark based on
confiscation.
I'm not familiar with all the arguments in those cases. So certainly, those are potential issues, but that is to be decided in other proceedings. Is not part of this case. This case is about whether, based on the arguments that have been made, the director properly renewed Cuba Export's registration on one of the two rationales.
Can I ask just a random question? So all this is about paying fees and how Cuba Export couldn't pay fees, but the appeal to the director required the payment of a $100 fee, right? There's an appellate fee. Why was Cuba Export allowed to pay that $100 fee? Right? Do you see what I'm saying? They weren't allowed to pay $500, and then they're told they can appeal, and they are allowed then to pay the $100 fee to appeal. Why? How is that? And was that void at the time it was given? What do I do with that? That seems odd.
Yeah, I mean, that's not an argument that's been raised by.
I understand, but I'm asking it.
Yeah, and to be honest, I don't know. I assume that there was, the licenses that are before this court are not the only licenses that have been at issue. So, for example, there was a specific license that was granted to Ropes and Gray to represent Cuba Export,
So maybe that included litigation fees, but doesn't include registration fees,
right,
or something.
That may be the case, or there may be another specific or general license that authorized that appeal fee. I just don't know, but no party has raised it, and I assume that's because there was no issue as to whether that fee was authorized.
And this is all about rum. Havana rum.
Yes, that's correct.
All right. Anything more?
I just wanted to take issue with Bacardi's characterization of the license as not applying retroactively. The license specifically referenced the payment that was made in 2005. And so the only reason for OFAC to specifically reference that past payment was to retroactively authorize it. Let's see.
Your colleague on the other side says, listen, they say they can take present action with respect to that, but it doesn't say it's retroactive.
Right. And I think to answer that, I would look to to OFAC's regulations. So at 31 CFR 515.203C,
Wait, sounds like 515.203C?
Yes. OFAC's regulations expressly provide that an appropriate license or other authorization issued by or pursuant to the direction or authorization of the Secretary of the Treasury before, during, or after a transfer shall validate such transfer or render it enforceable to the same extent as it would be valid or enforceable apart from the Cuba sanctions. So here,
This is your reverse of the reversal point.
no, my point here, I guess, is just to explain why we should interpret the license that was given to retroactively validate the 2005 and to direct that payment be treated as valid and legally effective. And that's to say that this regulation says that when OFAC authorizes a past transaction, then that authorization is retroactive to the date of that transaction. It's sort of a rule of construction, I guess, of licenses. What do we take to be the effect of this license that's been given? And because the license did refer to the past 2005 transaction, then it retroactively validated that transaction. And I would also point out that
It could have been clearer because OFAC really speaks in the present tense in their ruling.
And that's actually, what OFAC actually said is they use the verb to engage, and to engage is actually not present tense, that's an infinitive, which doesn't carry a tense. But I think the more important point is that the license specifically referenced the payment. Finally, I would just say that with regard to the first rationale, the retroactive validation rationale, I would disagree with Bacardi that the director had discretion, because what was presented to the director was an otherwise complete application, a payment that the examiner had refunded and rejected solely because of the lack of an OFAC license. And now the director was presented with a license that that retroactively validated the payment. The Cuba export had properly preserved the issue by filing a timely petition to the director. So by the time the director decided the case, the director had to apply the law as it stood at the time of decision, and the only result the director could reach was to, in fact, accept the payment as valid and therefore renew the registration. If the court has no further questions.
Thank you very much. All right, Mr. McElrally.
Thank you, Your Honors. Carl McElrally for intervener appellee Cuba export. I agree with everything that Mr. Shaw just said. I would like, though, to start by addressing Judge Niemeyer's question about why this registration is in Cuba Export's name at all. The Cuban government did not confiscate the U.S. registration. It couldn't have. It has no power over U.S. registration.
No, but didn't it confiscate the business?
It did nationalize the business back in 1961.
It nationalized the business, and of course, trademarks go with a business. They can only be linked to a business. A trademark doesn't stand independently of a business.
That's right. That's right, Your Honor. But what happened is, in 1973, the original owners allowed their trademark registration to expire. At that point, it was, as Bacardi itself pointed out, deadlines matter. At that point, the trademark was open for anybody to register. Cuba Export did register it at that point without.
I think allowing it to expire, it had no business. Its business was confiscated.
There's a concept of excusable non-use. If you have other former Cuban trademark owners have been allowed to register on that basis, that the expropriation of their property allowed them, gave them an excuse for not using the trademark. They could have filed it. They could have claimed excusable non-use. They didn't. Be that as it may, Cuba Export got its registration in 1976. That started a 5-year period running for them to challenge the registration. On the only exceptions to that 5-year are fraud, abandonment, and maybe 1 or 2 others. They did not. After that 5 years, there was
uncontestable. Is that the word?
It's a concept related to uncontestability. It's not exactly the same thing, but it is. Bacardi then, many years later, decades later, brought a claim that's now still pending 22 years later in the District of Columbia. There have been multiple proceedings and things have been stayed in favor of each other. They did try to frame it as a claim for fraud. That is still pending. that's not before this court. That's before another court. I see my time has already expired since I only took 2 minutes. Thank you, Your Honor.
Yeah, all right. Mr. Zients, you have a few minutes.
Thank you, Your Honor. I'd just make a few points. One, the issue was raised about didn't the filing of the petition stay the obligation to cure? Section 2.146G of the regulation, the mere filing of a petition to the director will not act as a stay, and then it goes on.
But it preserves the issue. In other words, the director could reverse, and when the director reverses, that removes the deficiency.
If the director concludes that there never should have been a deficiency to begin with, absolutely. I just want to make the narrow point that there's no stay of the time. If there was a deficiency, and the issue is how long do you have to cure it, filing a petition, and it says unless the end of this, except when a stay is specifically requested. Cuba Export didn't request a stay. They had no reason to think they were ever going to get a license. They made a whole other set of arguments about why they shouldn't be required to pay.
But we have the same thing in the judiciary. You request a stay and don't request a stay, and the plaintiff can start enforcing the judgment and so forth, but the Court of Appeals can still reverse and vacate the judgment. I mean, just as a director can reverse the deficiency.
Sure, if there is a basis for concluding that. The second point I want to make, I think Judge Richardson asked the question to the government, doesn't this give you limitless discretion here? I didn't hear a no. I didn't hear what the limits would be to that. It really is striking that this, effectively the exercise.
We give lots of discretion in lots of places, right? Maybe even more today than we did a decade ago, right?
And I would say two things about that. One, this was discretion used in a way that effectively nullified the scheme. This is supposed to expire. If this is a 10-year registration period, it wiped that out.
But that could have been challenged. I mean, that decision could have been challenged. We have a mechanism for doing that.
With respect to that, I don't think that's not the delay challenge. That's the decision. Mr. Shah said that the director implicitly extended the deadline by 10 years. Okay, that was final agency action, not a delay. A decision to give 10 years to cure. So that was, even Judge Richardson accepting that that's one of these ways in which the agency has a lot of discretion. Well, the agency also has to explain why. And when the agency is doing something that runs headlong into this very time-bound statutory scheme, at least you could expect some recognition that in a normal course you get 6 months. That's what the trademark manual says is the normal policy. There was some decision here to treat this as an exceptional and basically, give a benefit to those who have stolen this trademark. Explain why in this case that discretion, if it existed, was exercised. That's rationale 2. Going back to rationale 1, my friend Mr. Shah says he disagrees that the director had any discretion whatsoever once OFAC had given the license. A couple points about that. No one has a right. This isn't the Fourth Circuit. This isn't, the director must sit in review of every single denial of a renewal of every single decision by an examiner. There is discretionary authority to exercise supervisory authority in appropriate circumstances. That's what the regulation says. So there's absolutely discretion to say, you know what? This is not an appropriate circumstance to give a benefit to Cuba Export 10 years later after holding this open for reasons that I'm not going to explain. That is...
Actually, that's not totally fair. I mean, didn't the director recognize that the application was for registration, renewal, was all in order except for the payment license from a different agency? And when the different agency finally gave its authority for that license, they said that removes the only objection because otherwise the application was in order. There was nothing wrong with the application, was there? You haven't challenged the application except for the payment.
Right, but that's, and which is a statutory element.
And the payment was challenged because of a interpretation about a license requirement. The law firm did have a license, but it was construed not to cover the receipt of payments.
Right, and from 2005 until basically the end of 2015.
Well, that's criticizing basically the agency for sitting on it. I think it's a legitimate criticism, but I'm not sure that's before us.
Sure, but then I have very little time left and just want to make sure I get this in on rationale 1. I think the government would agree with this. Rationale 1 only works if this was a retroactive license. The regulation says it's not retroactive unless it specifically so provides. JA 523 is the OFAC license. It does not specifically provide it. It says you have authorized to engage. I won't get into infinitives versus present tense, but it says authorized to engage in transactions related to the 2005 application and the payment referenced therein. A new payment in 2016 absolutely is related to the application and the payment referenced in 2005. So there's an entirely...
What's your response to the 203C rule of construction argument?
I think 515,
I wrote down 203C, it might be something else, but
Sure.
the rule of construction argument that your colleague suggested.
The rule of construction is I think in our favor, that it is not retroactive unless it specifically so provides. Unless maybe I'm misunderstanding.
Right, but the question is, what is specificity?
Yeah.
Does specificity require magic words, right? You might imagine it said, unless you say retroactive, it doesn't count. The other thing you might say is like, it requires specificity, and that is like giving the December 2005 date is itself specificity, right? It's specific about what the retroactive piece is.
Well, it talks about the payment referenced in a December 14th, 2005 application, and it authorizes all transactions. You can engage in all transactions, including those related to that payment. So if we didn't have that clear statement rule in the regulation, maybe, but this is, it's sort of like when the Supreme Court recognized a kind of clear statement principle. If this license can be read two ways, and I think that is a fair description of this license. If it can be read two ways, then I don't think that meets the clear statement principle in this idea of specifically so provides.
Can I, with your permission?
yeah, sure.
So I'm just trying to make sure I understand this line. Imagine a world that the license said all the magic words, right? We give authority to be retroactive in every specification that would make you happy.
Sure.
In that scenario, wouldn't Cuba Export still have to take an action, right? Because currently the money's been returned, right? And so they would still have to take an action. That is, listen, we tried to give you this money once, you told us no, we're giving it back to you now, draw it down from my account, whatever, or from my Ropes and Gray account. Like, they would still have to do something in order to make it retroactive. So I guess I'm not sure why to take action
Right.
Undermines the retroactivity point, because everybody agrees, whether it's retroactive or not, there has to be some present action taken to effectuate even a retroactive payment.
Right, and I guess that's sort of a separate one of our arguments, which is why we think rationale one doesn't work. The payment actually happened. They had to do something to finish the payment in 2016. My point is only, I think OFAC, OFAC doesn't get to decide how things work under the Lanham Act, what counts, when is good enough. OFAC was asked for a license, for certain.
Why would it, if it was just giving a license in 2016, why would it refer back to 2005? It says 5.
Well, it was referring to, I think Cuba Export often OFAC will refer back to an application that was made in the request. OFAC, certainly Cuba Export, thought that they could complete this transaction that they wanted to engage in 2005. It was referring to that. I think what OFAC did is it said, okay, now you can engage in transactions that are related to that 2005 application, and then OFAC is done. And then it's the PTO's job to say, should I, how does this affect the timing requirements under the Lanham Act? Should I exercise my discretionary supervisory review authority under 2.146? A3, and how does this all work, and then explain why I'm doing that.
Okay.
Thank you, Your Honor.
We'll adjourn court for the day, come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.